Yes. You don't have all day. I'd like to call this Tennessee Real Estate Commission August meeting to order. I'd like to ask Miss Eve Maxwell, our Executive Director, to call the roll.
Alexander.
He's here.
Mike. Collins.
Here.
DeChiara. Here. Flitcroft. Absent. Grease.
Here.
Haynes. Absent. McMullen. Absent. Northern. Absent. Stevenson.
Here.
We have a quorum.
Okay. Thank you, Miss Maxwell. And Mr. Northern, he'll be here shortly. If I could at this time, I'm going to call on Commissioner Grover Collins to lead us in our invocation this morning.
Our Father, we give Thee our thanks for this day and all its blessings. We are thankful for the freedom we have to assemble in this country. We are thankful for this country. We are thankful for our troops that protect the freedom. We are thankful that we have the opportunity to work in this state freely and to earn a living. Be with each of us today, and we pray that what we say and do will be in accordance with Thy will. In Christ's name, amen.
Amen.
You have had a chance to see the agenda. Are there any additions or deletions that anyone would like to make to our agenda before we approve it?
I made a mistake and ran these copies
Kelly,
before
yeah,
I flipped it.
Before we
so
flipped
the one
it.
on the iPad is correct.
Right, with the legal report first, and the I just want to make sure, like, the legal, we flipped, so the legal report would be first this morning, and then the instructor
Just
course
reverse
information.
it.
Just sort of flips. I don't know. Is that what's on the iPads?
Yes, that's what's on the iPads. That's what I get for doing enough work ahead of time.
Well, we don't need the paper.
I just wanted to make sure that was correct, so that everyone.
I'm sorry.
You know, really in the whole scheme of things, the order in which we go doesn't really matter, because at the end of the day, we're going to have to cover everything.
I know. I just didn't want you to start out with
I didn't even notice
like
that.
one thing. That's
Mr. Chair,
Yes.
I would like to add an item to the agenda that we discuss our meeting schedule.
It's on the agenda down under the Executive Director report.
Well, what I want to discuss is different than that schedule.
Okay?
Once we get to the meeting schedule.
And I would like to discuss an issue that has been brought to my attention from a licensee and a gentleman who has a school in East Tennessee about a broker. What happens when a broker fails to get within a 3-year period all of his 120 additional hours for his requirement for his broker's license? What happens at that point? Is he still an affiliate broker, or because of the situation of a gentleman that he was relating to me about just didn't have a license anymore because he didn't get it done within that 3-year period? Anyway, we'll just I would like to add that to somewhere, probably down under the Executive Director's report, right after policy review down on the bottom. Is just discuss that issue and look at that. See if we need to consider doing anything about how that is handled. Anybody else have anything they'd like to add to our agenda? Hearing motion made approved as amended. Commissioner Alexander makes a motion we approve our agenda as amended. Do I hear a second?
Second.
Motion and a second. Any discussion? Hearing none. All in favor say aye.
Aye.
Opposed, no. Motion carried. Next, we have our minutes. Approval of our minutes.
Motion to approve.
I have a motion to approve. Do I hear a second?
Second.
Commissioner DeSharrow makes a motion to approve, and Commissioner Grease seconds that motion. All in favor say aye. Opposed, no.
I'm abstaining.
Let the record show that Commissioner Collins is abstaining since he was not in attendance at our July meeting. And I'd like to welcome our commissioners from West Tennessee, Mr. Isaac Norman. Take a seat. He's our chairman emeritus. Now, no, Isaac will never be a has-been. Now, our legal report's next on our agenda. Julie Crawford.
Before I begin, Ms. Ryan's here. She wanted to update you all with what happened with the litigation that was set for today briefly.
And I want to tell you what's happening in that litigation. We have litigation scheduled for next month. We'll have one set for October. It's at Lugar. I have one set for November. Can I guarantee they'll take off? Can I guarantee that we'll have a hearing? No. Can I guarantee that the settlement is like one ahead of time? In any event, yesterday's case, today's case did settle. We have an attorney. He paid the civil penalty as proposed by this commission previously. And the issue was an escrow account, and I want to know he also paid the entire deficiency for the escrow account he got and is in good standing on the issue that would have been presented before you. I also wanted to assure you that I attend these meetings only in the legal report, not just for the Tennessee Real Estate Commission, but all the commissions I work with. We're sort of asked to do that so we can work hand in hand with the attorney and know any issues that might come up for litigation. You should know that Julie doesn't need me here, as you probably already know that. But she and I discuss everything beforehand, as I do with all the board attorneys, and if there's a question or issue that might involve litigation, that's part of the reason I'm here. But I'm only here for the legal report and to sit here and be silent while she does her magic stuff.
Just out of curiosity, how many other boards and commissions do you work with?
I work with I want to say personal injury, but it's not. It's private investigators, locksmiths, collection services, and motor vehicle commission. Yeah, I do the litigation for all of them.
Okay. Commissioner Grease?
Mr. Chairman, Robin, can you give us the general details of the case that was settled? And the term settled, was it settled or did they agree, did the respondent agree?
Well, the way it works is this. A case is presented to you all, you propose a civil penalty and the terms of the agreement. Up until the date of trial, the respondent has an opportunity to comply with the terms of the consent order as previously proposed. So that's what happened.
So he complied. You didn't negotiate.
No, I don't negotiate. I can't negotiate for you all without your permission, and I don't have that permission.
Can you tell us what he agreed to, what the fine was?
Well, the fine was the civil penalty he paid as previously determined was $9,000. But there were two respondents, $5,000 for one and $4,000 for the other.
And what was the nature? It's before my time on this board. What was the nature?
Well,
of the
I'm not really comfortable talking about it now. It's not fair to the respondent, as he has already resolved it. You have already discussed it. But I will tell you, it had to do with issues that had from a number of years ago when he took over from partners, and he resolved it and paid the civil penalty as proposed by you all at a previous meeting. He is also to attend a 2-day meeting of this commission. As with all consent orders and agreed orders, should he not comply with any of the terms, and right now the only term that remains is the 2-day meeting of this commission within 6 months, any respondent who signs a consent order and agreed order who does not comply gets their license automatically suspended if they don't comply.
One more question. At some point, that case is going to be published.
Well, the results will be published.
Well, but it'll indicate the nature of the offense.
Yeah, it was failure to timely account for monies belonging to others.
Okay. Thank you.
Mr. Chair, this might be a good time to discuss what I was asking be added to the agenda.
Commissioner DeSharo, you have the floor.
Since we plan our meetings around the hearings and have the hearings on the first day, and then when that doesn't happen, it throws us all out of whack. Why can we not move our hearings to the second day? And then if they're canceled, then it won't be as much of a craziness as it is right now.
I think I can sort of address that. When I originally started to do hearings, they were scheduled on the second day. The problem is, as this commission knows, sometimes the hearings go very long. Last year, when we were in Jackson, our hearing went for 9 hours, and that proposes a problem for all those who have to travel on the second day. And so you all had decided previously to put it for the first day. And I'm very sorry that I can't handle the dynamics of litigation better than that, but I can't. That's the nature of litigation. Frankly, up until the day of the hearing could also be continued, and we can't really necessarily anticipate that either. But that was the reason it had been switched to the first day, because in case it went over, you could continue the hearing on the second day or continue the meeting on the second day if it had gone very long. And that was part of the reason. I don't care when you do them. It's really up to you all. I just need the day that you have each month. I do have a bunch in the lineup that will need to be presented.
Well, I understand we can't change what's already scheduled, but beyond that, you know, I don't know why we couldn't.
I think it's unfair to these people in the audience. I'm sure some of them looking at this list probably made hotel reservations tomorrow night, or for the night, tomorrow night. And they're going to get the credits for one day, and they're going to be able to go home. So if you've got a motel room scheduled for the night, you can cancel it. So we're going to give you 16 hours one day.
8 hours.
8 hours.
8 hours of it. 8 hours. One day meeting. I think that since we're paid so well to do this, as part of the breaks that we had to stay over on that second day for a hearing, or be a little bit late, I think it's better to accommodate public than it is ourselves. That's my personal opinion.
See, I just say one more thought about that. Occasionally there will be people that want to speak to our agenda items, and if the initial agenda shows that it's going to be on the second day, the topic, and then all of a sudden it's moved to the first, it's likely they'll miss the topic that they wanted to speak about. I'd like to fix the business section, the session, this first day, and if I get home at midnight on the second day, that's goes along with the territory.
Can I just say something about hotels too? If we get done late in the day on the second day, like if we were to unfortunately go 9 hours on
We can't.
I know let me explain the microphone situation too. They unplugged those speakers, and so with the purpose of making all the mics even, but it's really kind of, it seems to me maybe made them all work less loudly. So so I apologize. So everybody needs to like talk really loudly now. So anyway, what I was saying is if we were to go 9 hours on the second day, especially if we were out of town where I have to make a lot of arrangements to get hotels for the state rate, there's nothing assuring me that I could call up and say, we got to stay an extra night. And they'll have 9, 12 hotel rooms available. Does that make, even here, although we'd have better luck here because we have an established relationship with Sheraton, if we had to stay an extra night?
Well, I'm kind of like John. We might have to stop at a hotel on the way home, or move hotels, or just drive home.
I just don't want to get in a situation where we have like another, like the one in Jackson went 9 hours that day. I can't always promise that I can call up the hotel and say, I need another 12 rooms at the state rate for another night.
Think about it, I've been on this commission for 8 years now, and that one was just a fluke. That's the longest one we've ever had. We've never had one anywhere near that length of time.
Let's just see how Chairman, I'll make a motion that we move the hearings to the second day.
Okay, now we already have You have one scheduled for September, October.
And we can't do that for December either because we have the ALJ available as the first day. So this year, we are stuck with what we have.
Okay, for beginning January 1, we will have, if this motion passes, we will have the hearings the second day.
I'll second that motion.
We have a motion by Commissioner Alexander and a second by Commissioner DeShara that beginning January, that any formal hearings that's heard before this commission will be on our second day of meeting rather than the first. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously. Now, you have anything else, Ms. Ryan?
No, unless anybody has any questions.
Okay. Ms. Crop?
Okay, I'm going to start by reading the statement at the top of the legal report. Any consent order authorized by the Commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. First matter on the legal report is 2012-001941. Complaint was opened against respondent, a retired affiliate broker, based on an original complaint received against a timeshare registration. Based on the information received from complainant paid respondent's company to transfer an out-of-state timeshare out of their names in 2010, and the transfer has not been completed. Respondent submitted a reply stating that respondent's company began the process of transferring the timeshare in 2010. Respondent claims that the resort at which the timeshare is located has changed their transfer policy and requires a higher transfer fee, which respondent was not aware of. Respondent states that respondent requested the additional amount from complainant but has not received it, and so the transfer of the property has not been completed. Based on the information obtained by Trek auditors, it appears that timeshare owners contact respondent and pay transfer fees to respondent to be relieved of their timeshares. In some cases where there are unpaid maintenance fees on the timeshares, it appears that respondent takes over the ownership and pays outstanding maintenance fees. Though complainant may certainly have contractual issues with respondent, the documentation contained within the file does not evidence unlicensed activity on the part of the respondent with regard to this transaction, and therefore the recommendation is to dismiss.
You've heard the recommendation of counsel. What's your pleasure?
Motion to dismiss.
Have a motion to dismiss. Do I hear a second?
Second.
Any discussion on the motion? Commissioner DeShara makes the motion and Commissioner Collins seconds that motion. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carried.
2 and 3, 2012-006651 and 2012-006652. Complainants state that they leased a home from respondents. Both are unlicensed. Complainants were relocated to Tennessee from another area of the country and selected the home to rent, which was shown on respondent's website. Complainants state that the photos that were provided of the property on respondent's website were not the actual home complainants rented. Complainants state that the home was very dirty and unfit to live in. It appears that Respondent 1 was a licensee whose license has expired. Respondent submitted a response stating that they are married, and Respondent 2 entered into a lease option agreement with the owner of the subject property rented by complainants. A copy of the lease option agreement was provided by respondents. Then Respondent 2 personally entered into a rental agreement with complainants, which did not involve Respondent 1 or their company. It appears that the maintenance and cleanliness issues addressed in the complaint were handled by attorneys for the parties. Respondent 1 states that upon realizing Respondent 1's real estate license had expired, Respondent 1 shut down their company and has ceased operations. Respondent 1 plans to affiliate with a firm. With regard to, Respondent 1 is in the process of taking the exam and obtaining proper licensure, at which time Respondent 1 plans to affiliate with a firm. With regard to the property that was rented by complainants, it appears from the documentation provided that Respondent 2 was renting the property to complainants personally, pursuant to the rights granted to Respondent 2 by a lease option agreement with the property owner, and therefore the recommendation is to dismiss.
Julie, there's no information at all at the top up there about the licensee. So, I mean, their license was expired, but how long ago had it expired?
I may not have that. Is there a way we can check that?
While they're looking over there and we have a lull, I'd like to welcome Chris Saxton, who is the liaison with the Tennessee Association of Realtors here today, and also Miss Cindy Rice, who is with Rice Insurance, who is the carrier for the errors and omissions insurance that most of our licensees carry. I want to welcome her. They're both sitting up here on the front row. Cindy Rice Grisham, excuse me, Commissioner.
I remember when she was just licensed.
Also, I've just been informed that we have two members of the Williamson County Board of Realtors who are here observing, so they're going to report back to their board. We have Karen, what's your last name, Karen? Karnacki? Zarnacki. Okay, Karen Zarnacki, and also Paula Cirilli. Okay, good to welcome you two here. And you have one, who's that in the middle? Lisa. Liz? Okay, Liz, all three of y'all are from the board? Well, who's manning the store today? Somebody else.
I clean right here.
Okay.
This person's license expired on 1/23/10. And I did confirm through our licensing system that there are notes in there that this person is going through the process of licensure. I think there was a note in there saying that they've been approved to take the exam on it.
So they've been practicing real estate without a license? No?
2 years.
I'm not sure exactly what has been going on with regard to anything except this particular transaction that the complaint was submitted on. They gave me documentation in that instance that there is a lease option agreement between the owner of the property and respondent to personally. And the lease contract between these complainants and is with respondent to personally, not through a company. The documentation I have for this transaction indicates that it was him operating under a lease option agreement. As to what else,
Website is this information.
it was a website that was up at one point. They had pulled it down. They said, I realized, she said,
Part of the company's advertising.
it said that there were other properties on there. Once I got the response and started looking up, there was no website anymore. It was pulled down. And this person indicated that she had been in Florida and didn't realize that the license had lapsed. I just don't have a lot here except for with regard to this complainant, I have the lease option agreement and I have the lease agreement. With regard to that, it all appears to be with respondent personally, and I don't have anything to show otherwise. And with them being unlicensed, we can try to send somebody out to investigate and get more documentation, but at this point, all I have is with regard to this transaction.
I'm not sure the complaint rises to the level of some action from this body, but it does appear that they were doing business in a deceitful manner, because it would appear to me that if they've got a website and they've got other properties, they're conducting a business in real estate.
Well, I think...
I'll welcome your response, Ms. Ryan.
That was not meant that way. I'm not interrupting Julie, but she and I did discuss this. The problem is that what Julie found was that all the issues related to an interest he had himself in the property, she's not involved in all, and all the issues related to a piece of property in which he had an interest in. You can rent your own properties. You can sell your own properties and rent your own properties, as many as they are, and he had that interest in. That's what Julie had. And and we discussed this at length, and she did a lot of investigation on it, and there was nothing to show beyond that. Now, maybe something else was happening somewhere else, but in this particular complaint, with this set of circumstances, his rights and interests, he had the right to do what he was doing.
I guess my concern is the website, and I would like to know a little bit more about that, because if this was an active rental on an active website.
But you can still advertise your own rentals on a website.
Well, that's why I'm saying I think the website is the key to it as to whether they were advertising that as a company or whether they were advertising that independently. Do you have the company website name?
I have printouts from the website that was formerly up. Like I said, when you go to that website now, it is no longer an active website. But I have printouts from that came in, I'm assuming, around the time of the complaint prior to when this was pulled down. Like I said, I can't go on there and actively click through it anymore because it's no longer. I believe that might just be anonymity. Would somebody maybe like to take this voucher? Would a commissioner
I
maybe like to
think
take
so.
it? I don't think I can give that out because it might ruin the.
I'll be happy to take that file that you need to
Okay.
go through.
And just one more issue, at least in the narrative here, it said when Respondent 1 found out that their license had expired, they closed their business.
I know.
Well, that's 2 years later, is that right?
I just-
Approximately, if their license expired in January of 2010 and this complaint was opened in April of 2012. And then to follow up with that, they're in the process of taking the exam. Now, what exam would yeah.
Well, and the fact they, like you said, they admitted they closed a business.
And like I said, the information I got was from this respondent because that's the only the complainant doesn't have information, and I could only get, what she would give me. And
I think, based on the discussion and the comments that have been made, I think Commissioner Grease made a motion that we defer this and let Commissioner DeShara take the file and report next month, and I think Commissioner Alexander seconded that motion. Do I hear any discussion on that motion? Hearing none, all in favor say aye. Aye. Opposed, no. Carry on.
Number 4, 2012007861. Complainant states that respondent timeshare salesperson forged 2 signatures, both complainant's signature and the signature of the other owner of the timeshare, on a warranty deed executed in Tennessee, which transferred the ownership of complainant's out-of-state timeshare to respondent. Complainant realized this when complainant, a resident of another state, inquired about maintenance fees and found the address had been changed. Complainant states that the sale was not authorized. Respondent states that a title transfer company transferred the title share into respondent's name. To respondent's understanding, complainant signed a contract with a company and paid them to have the timeshare transferred out of complainant's name. Then that company used the title transfer company to transfer the timeshare out of complainant's name. Complainant made an additional response appearing to admit to signing a consent form, but says that the process was contingent upon the other owner's signature, and complainant says that complainant had asked to cancel the process. Complainant says that the title transfer company offered to put the timeshare back into complainant's name, but complainant does not want the property back and only wants the original purchase price. Based on the documentation received from the title company, it appears that the timeshare was deeded back to complainant. Additionally, the company which complainant met with in Texas and whom complainant contracted with and paid to rid complainant of complainant's timeshare obligation provided documentation of the meeting and payment and stated that complainant was refunded the money paid for the timeshare transfer. Based on all the documentation received from the parties, it appears that respondent's only involvement was taking over the timeshare. However, respondent was broker released from respondent's previous broker in May 2012, and to date, respondent has failed to either affiliate with a new broker or retire respondent's timeshare license. Therefore, the recommendation is a consent order for $500 for failure within 10 days after being broker released to complete the required administrative measures for either a change in affiliation or retirement in violation of Tennessee Code Annotated Section 62-13-312B14 and Rule 1260-02-.02 subsection 2, plus attendance at a 2-day meeting of the Commission within 180 days of respondent's execution of consent order.
Make a motion, we accept council's recommendation.
Second.
I have a motion by Commissioner DeShara that we accept council's recommendation, seconded by Commissioner Alexander. Any discussion on Commissioner Griggs? I'm sorry.
Hey, look, Griggs.
We sound alike. That's the reason I'm trying to call him by name to help you.
Thank you. They really do sound alike.
I know it's, I'm just showing that. Yeah. Any discussion?
That's kind of where I've been.
Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carried.
Number 5, 2012-008341. Complainant states that respondent, an unlicensed individual from another state, operates a website which sells MLS broker packages to Tennessee residents. After an individual purchases a package, complainant states that respondent's site shares a portion of the fee with local real estate brokers to list the property on MLS. It appears from examining the website that respondent's site offers this type of service in all states. Respondent submitted a response stating that respondent has evidence that the complainant is
No rustling paper.
Respondent submitted a response stating that respondent has evidence that the complainant is a relative of a disgruntled licensed real estate broker in another state who used to do business with respondent and is now filing complaints with regulators in every state to harm competitors and retaliate against respondent. Respondent states that respondent's site does not hold itself out as a broker in Tennessee, but instead provides real estate sellers with advertising services similar to newspaper listings. Respondent states that respondent provides homeowners with web pages for advertising properties and provide licensed real estate agents who offer discounting listed services with an advertising and marketing venue to reach sellers. Respondent states that the site provides advertising and marketing services and does not offer real estate brokerage services or receive fees conditioned on closing or calculated based on sales or offer prices. Based on the information contained within the file, there does not appear to be evidence of unlicensed activity on the part of respondent, and therefore the recommendation is to dismiss.
Move to dismiss. Second.
Motion to dismiss by Commissioner Northern and a second by Commissioner Collins. Any discussion?
Just one point of clarification. So the respondent says he or she does not receive fees from Tennessee brokers.
He said that he says that they don't receive fees that are conditioned on closing, or I guess they don't receive any kind of commissions, portion of the commissions from any sale of these properties. We kind of get into this a little bit in the next one. The next complaint is opened against a Tennessee real estate broker who is then listing the properties. We had an auditor go out, and they did obtain a copy of a referral agreement between this Tennessee broker and I believe it's this respondent's company, wherein they do receive a referral fee as part of that listing package that they create with this broker. But this respondent out of state has a real estate firm licensed in the state that company is in, that is affiliated with them. The referral agreement is for that out-of-state licensed firm to receive part of the commission, which under our statute, as long as they're not coming in to negotiate. It gets a little more into that into the next one, but that is the general situation of what appears to be going on.
There's a lot of information on an upcoming case that could impact the current one.
Okay.
Call for the question.
Well, I have a question about this one. It says that they're mailing out MLS broker packages.
Mailing out, I think they purchase them online.
Well, operates a website which sells MLS broker packages. What kind of information are in those packages? Is it TAR forms? Is it?
It's hard to tell. What it appears is they offer a website, and it might it's like a for sale by owner website where they can feature it on there, and then my understanding is they're hooked up with these brokers in Tennessee who then put them on the MLS system.
But you didn't see the package, the MLS package that they're downloading.
I have not. All that I was provided with, because this is from a company almost across the country. We sent the auditor to the in-state brokerage. We got copies of the listing contract between the owners of the properties and this broker, but he didn't have documentation of what is between this out-of-state respondent and the individual owners.
I'd be interested to see what those forms were on that website.
Question has been called on the motion. All in favor say aye. Aye. Opposed, no. Motion carries. Number 6.
Number 6, 2012-008361. This is the same complainant as the previous matter. This matter was opened against respondent, a principal broker who was also referenced in the complaint. Several of the properties featured on the previous respondent's website also have listings on Realtor.com with this respondent's name on them. Respondent submitted a response stating that the complainant is a proxy for a licensed real estate broker in another state who previously had the same relationship with the site as this respondent. Respondent also states that the previous respondent's site operates a website for individuals wanting to sell their homes by owner where the sellers can advertise their properties. Respondent states that for these sellers that want to feature their home on the MLS, the previous respondent offers a service to match the individuals with a licensed broker in the state to list the properties on the MLS for a fixed fee. Respondent states that the previous respondent has never paid any kind of payment contingent on closing or as a function of real estate sales or offering prices. Based on the information obtained by a TREC auditor, it appears that the respondent enters into a listing contract with an interested for sale by owner seller and is paid a flat fee for listing the property. It appears that respondent pays a referral fee for those listings to a real estate firm which is licensed in another state and is connected with the previous respondent's website. Based on the information contained in the file, there does not appear to be a violation of TREC statutes and/or rules by respondent, and therefore the recommendation was to dismiss as to this respondent.
Motion by Commissioner Northern to dismiss, and seconded by Commissioner Collins. Any discussion? All in favor say aye. Opposed, no. Motion carries. Number 7.
And did you all vote to defer the previous one, or? I'm sorry. Okay, I got confused. All right. Number 7. This is a complaint submitted by the same complainant as the previous 2 matters against respondent, a broker in another state, unlicensed in Tennessee. Complainant states that several websites sell a Realtor.com package to Tennessee residents and then pay this respondent to list the property on the MLS system. Respondent submitted a response stating that the complainant is a fake name made up by a real estate broker from another state whom respondent states is involved in an ongoing criminal and civil matter. Respondent states that respondent is licensed in another state and provides for sale by owner sellers with an MLS listing for the purposes of advertising the home on Realtor.com. Respondent states that the respondent puts in the home on Realtor.com and then forwards all calls and emails to the seller and no commission is being offered. Respondent states that the respondent does not provide real estate services outside of the state in which respondent is licensed. Based on the information contained within the file, there does not appear to be evidence of unlicensed activity on the part of respondent, and therefore the recommendation is to dismiss.
This person's not licensed in Tennessee.
He is not.
The respondent is not.
The respondent is a licensed broker in another state.
How are we hearing it here?
This complaint was sent in, and we opened complaints that are received from, this complainant is the same complainant that submitted the complaints against these 3 individuals, so the staff opens the complaints that are received.
Would it have been proper just to tell this individual that we don't have jurisdiction over this individual and move on? There's no complaint here.
These are being offered to Tennessee residents, so that's why the connection that Tennessee had with it was being sold to Tennessee residents. Because he's out of state. I'm actually doing this in a whole lot of states, but that's why it was open, is because it was dealt with people who lived in Tennessee.
I think this is one of the virtual office issues with the limited services. And I think they probably would have to be policed in the state, which is affecting residents because they're just out there in la-la land.
What's your pleasure on this complaint? Recommendation is to dismiss.
Let me ask one more question.
Commissioner Green.
So, let's say somebody's looking for a house in Tennessee and they go to Realtor.com, and one of these for sale by owners shows up. It'll have a real estate company's name on it, won't it?
It has this person's name and discloses that it is a California real estate broker on it. I'm sorry, an out-of-state real estate broker on it. I don't imagine there's a lot of brokers in California. I doubt you know him.
Yeah, you didn't narrow it down that much.
It discloses that it's an out-of-state broker. There is an 800 number there that is the contact number. The way this person explained it is the calls are directly routed back to the individuals who own the houses. the way it was explained is that if it's put on Realtor.com, there has to be a realtor as the contact putting it on there. And the way this person explained it is, I'm putting it on there, I'm disclosing that I'm out of state, and all these calls, any negotiations are going straight to the seller. I'm just doing this listing package. I'm just putting it on the website.
Does that at all fall in the category of providing real estate services?
Well, this was something new to me, so I reviewed it, and I talked with Ms. Ryan about it, and I had Mr. Pugh look at it as well. He took the file and glanced at it. The thought that they are not coming into the state to negotiate this, they're just putting the listing on there, not negotiating the sales price. They contact them and go, I'm selling my home, this is what I want it sold for, and they're just putting on the website. The determination we came to was it didn't clearly fall into that definition, and we have very limited information on this because this is taking place out of state, and we can't send an auditor or an investigator out there to forcefully get this information. So from what we have, it doesn't appear to rise to that level, but it's...
I think this is another one of those issues we're going to have to learn to deal with the internet being as prevalent as it is. And I think this is a first of many to come. One of my concerns is what kind of forms they're getting.
You know what, if I can make a comment right now. When we have the three legal minds, Ms. Kropp just informed us, have looked at this issue, Robin Ryan and Wayne Pugh and Julie, all three having looked at this, and as well as they know our statute, if I could make a motion right now, I'd make a motion to dismiss, because I feel that they have looked at this, researched this, and this recommendation is correct. Just thought I'd throw that in.
Motion to dismiss.
Have a motion by Commissioner Collins to dismiss, and a second by who?
I'll be glad to second it, but I have one more question.
Okay, now discussion.
Okay, so those three legal minds took a look at it. Did you figure out where the threshold is?
The problem is what you have to, this is unlicensed, the allegation is unlicensed activity. That has to fall within parameters of your statute's definition, and it doesn't.
Well, how close did it get?
Well, it doesn't get close unless you can show that it's tied to a commission or sale of a particular piece of property, and based on that, read the definition, Julie, of what a broker is and what licensed activity is. The whole thing.
I'll take your word for it. I'm just...
And it doesn't. And it does not. And when you looked at the definitions and all the case scenarios that Julie provided, go ahead.
This might just clear it up, and I was looking for this. This is what Mr. Pugh had pointed to, and this might resolve it a little better. In this case, this person's out of state, and to our knowledge is not coming into Tennessee to do anything. 6213-301 basically states, and I don't want to read it word for word, that it is unlawful for someone to engage in conduct or act in the capacity of doing the activities as defined under the definition of broker within this state. And Mr. Pugh's thought was that this person is listing this from the other state, disclosing that they are from the other state, and they're not coming into Tennessee to engage in any of these activities. And therefore, it would be hard to cite someone with this unlicensed activity, the license requirement statute for unlicensed activity, when that is the way it's worded, and we have no evidence at all of this person coming within the state to perform any of those activities.
So we really, at this point, can't protect the public if the public lists their property with somebody from out of state, as long as they stay out of state.
And they're not doing anything within this state that rises to the level of the definition of broker requiring a license in the state.
All right, Mr. Chairman, I'll call for the question.
Question on the motion has been called. All in favor say aye. Aye. Opposed, no. Motion carries.
It appears to me on that particular situation that the realtors and MLSs of Tennessee would have more possibility to file suit for using these services that the rest of us have to pay for than the check would have in enforcing them.
This time I'd like to welcome Austin McMullen, our commissioner, another legal mind that was appointed to the commission from here in Nashville. He is one of the 2 consumer members on the commission. There's 7 of us that are industry members, and Commissioner McMullen is a consumer member appointed by Governor Haslam. Governor Haslam did an excellent job when he chose you.
Thank you, Mr. Chairman. We had some criminal suspects on the loose this morning that we had some fun with chasing, so I was trying to help out with that. I apologize for being late.
I was going to say, your job comes first.
Cops and robbers.
Okay. It's pretty exciting stuff compared to this.
Did you catch the suspects?
I think we got 1. There's still 2 they're looking for. Watch the news tonight and they'll probably tell you. Was.
Number 8, 2012-008-801. Complainant is with a resort in Florida who is inquiring about Respondent, an unlicensed LLC, and its involvement with the sale of a timeshare to 2 different parties. Complainant states the complainant has a recorded deed stating that Respondent handled a sale through a limited power of attorney, transferring the timeshare to an individual who allegedly resided in Missouri. Complainant states that the mail to this individual was returned to sender as unable to forward. When complainant contacted Respondent to ask for another address, complainant states that complainant received another recorded deed through a power of attorney, transferring the property to different individuals allegedly residing in Pennsylvania. Mail to those individuals was also returned. Complainant would like to know who owns the timeshare and obtain a correct address so that complainant can be paid past due maintenance fees. Complainant provided copies of both power of attorneys and copies of the deeds prepared by Respondent. Legal counsel contacted the original owners of the timeshare who stated that they dealt with and paid a company from another state to release them from their timeshare, and Respondent handled the title transfer work. It appears that the original owners executed a power of attorney and the timeshare was transferred to the first individual, and later executed another power of attorney and the timeshare was transferred to the second individual. Respondent replied stating that the 2 deeds were mistakenly prepared to deed both weeks to the 2 different individuals, and 1 week should have been transferred to the individual from Missouri and the other week to the couple from Pennsylvania. Respondent has indicated that it is working to resolve this mistake. Based on the information contained within the file, it appears that the original owners arranged and paid the out-of-state company to relieve them of their timeshare, and Respondent only handled the title transfer paperwork. And while complainant may have a private action against Respondent for the mistake in the deeds, the information in the file does not appear to contain evidence of unlicensed activity on the part of Respondent, and therefore the recommendation is to dismiss.
So moved.
We have a motion by Commissioner Bishara to dismiss. Do I hear a second?
Second.
I have a second by Commissioner McMullen. Discussion. Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 9 and number 10 next.
2012-013-821 and 2012-013-801. Complainants purchased a timeshare in another state with the condition that a transfer of title would take place to release complainants from their existing timeshare. Complainants state that Respondent 1, an unlicensed entity, same Respondent as the previous matter, was to facilitate the transfer. After several months, the required information to complete the transfer was received from the resort for complainant's existing timeshare, and a quitclaim deed was filed by Respondent 2, a firm. Respondents state that Respondent 2 did not make payment to the resort for their existing timeshare, resulting in that resort's refusal to acknowledge the transfer, and complainants continue to be billed for maintenance fees, resulting in the matter being turned over to a debt collection agency. Apparently, the representatives from Respondent 1 have been in contact with the collection agency and promised payment would be made, but it was not received by the collection agency. Respondents submitted replies stating that Respondents are in agreement with the resort where complainants purchased their new timeshare for Respondents to help transfer properties taken in by that resort as trade-ins. Respondents deny that they have any contract with complainants, but state that complainants' exchange contract is with the resort where they purchased their new timeshare. Complainants state the resort for the complainant's old timeshare has changed its transfer requirements 6 times in the past 7 months, resulting in the deeds constantly being kicked back, despite Respondents' attempts to transfer the properties. Respondents state that a refund was given to complainants for the transfer fee to the resort for complainant's old timeshare. Respondent 2 attached copies of a letter from the resort where complainants purchased their new timeshare, instructing complainants on what to send to Respondent 2 to complete the transfer and the fee for same. Additionally, Respondent 2 included a timeshare sales agreement signed only by complainants, wherein Respondent 2 was to buy complainants' old timeshare with no money to go to complainants, and complainants pay a transfer fee, which was to go to the resort where the old timeshare was held. Finally, Respondent 2 completed signed copies of a consent form, a power of attorney, and copies of a check from complainants to Respondent 2 for the transfer fee, and a check from Respondent 2 back to complainants reimbursing the transfer fee. The information in the file does not evidence unlicensed activity on the part of Respondent 1, and any dispute that complainants may have with Respondent 2 appears to be contractual in nature, and therefore the recommendation is to dismiss.
What's your pleasure?
Move to accept council's recommendation.
Second.
Commissioner Grease makes a motion we accept council's recommendation and dismiss, and seconded by Commissioner DeShara. Any discussion?
Just a quick question, Julie. How long did it take you to reduce what you did to this narrative? I mean, is this a couple hours worth of research right here, or a couple days?
This one took a while because I was trying to gather all the information I could, and that involves phone calls and requests for information. So it took a little bit of time. I hope it's not too confusing.
No, it's. No, it's not.
Any other discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. I'd like to say before you go to the next one, number 11, this is the reason, a point you just brought up, Commissioner Grease, is the reason I made the comment I did in Jackson last month. You are doing a wonderful job taking so much information and compiling it down into short form to present to us.
Thank you.
You're doing an excellent job.
Okay, I'm glad y'all can understand it. Sometimes it's hard to make it. All right, number 12, 2012-00857.
They promised they're building in Concord.
2012-00857-1. Complainant is a tenant in a property that is managed by a company owned by a respondent or retired affiliate broker. Complainant lists a number of issues with the management of the property, such as the company's utilization of a portal which the tenants can pay rent due to the fact that the company has a digital office. Further, complainant states that respondent's license is not active, the company is unlicensed with TREC and never has been licensed, with no principal broker, and that unlicensed employees of the company are performing acts which require licensure. Respondent submitted a response stating that respondent's company is an LLC registered with the state, with respondent and one other member. Respondent claims that the company manages property that the owners of the company either own entirely or have substantial ownership interest. Respondent states that the company has never been represented as a real estate firm or being licensed by TREC and uses independent contractors to help with managing its properties. Additionally, respondent states the company does not have a principal broker and has never been licensed because it does not hold itself out as a company involved in a real estate brokerage. Complainant submitted an additional response with documentation. In response to respondent's statements regarding owning or having a substantial ownership interest in all properties they manage, complainant researched the title and deed of trust for the property which complainant is renting, and all documentation references ownership by another individual with no mention of respondent, the company, or the company's other member. Complainant also attached printouts from the company's website and pointed to language that states that the company is a full-service real estate company that manages residential properties. Further, the page states whether you are looking for your next place to call home or someone to manage your real estate investment, you can trust the experience of, and it lists the company name. Upon researching several of the featured rentals from the printout on the state tax assessment website, the ownership information does not include the names of respondent and the other member of the LLC or the company. Respondent did not provide any proof to support any ownership interest that respondent, the other member of the company, or the company may have in the subject property or any other property managed by the company. Therefore, the recommendation is a consent order with a civil penalty of $1,000 for operating a property management firm without a license in violation of Tennessee Code Annotated Section 62-13-312B14, Tennessee Code Annotated Section 62-13-309A1A, which requires each office to have a real estate firm license, a principal broker, in a fixed location with adequate facilities for affiliated licensees, plus attendance at a 2-day meeting of the Commission within 180 days of respondent's execution of the consent order.
Any questions of Julie or any?
Comment. These are unlicensed individuals, so they're probably not going to attend our meetings.
This individual is a retired licensee who this complaint was opened against. It's an individual.
Not licensed now.
Well, he has retired license. There is a license. It's in retirement status. Yes, sir.
I would ask the question is where was the principal broker involved in this?
There isn't one. It's an unlicensed company.
He was licensed, none of this activity happened while he was with a brokerage firm?
Does not appear to. It's a name of
So it
another.
all happened since he retired his license 4/23/12?
No, he was doing all this without a broker.
Right.
It was separate from anything else he may have been doing. All the documentation I have is it's a separate.
Question I have, is the consent order going to make any reference to them stopping this action?
I think typically it says that they must comply with all real estate laws, but we could put something specifically in there, a cease and desist type.
I think it needs to, because that's the nature of
All
the
right.
problem.
And I'm not, is that
Is
fine
there no
as
other
much
violation that we can get from it?
as, is that fine enough?
Well, it's maximum under the statute. for
That's
one.
what I'm asking, because we've got two statutes
I
there.
don't know what's in there that they violate.
Sometimes it's a little tricky because it's not, these statutes are a little hard to write specific ones. The license requirement statute is talking about a person engaging in conduct or acting in the capacity of a real estate broker, affiliate broker, timeshare salesperson without a license. This person does have a license, so that would be hard to write under. I don't know.
Use their license.
Another problem is that this person has been very careful to not have his name on a lot of the documentation, and it's one person's work.
Someone who knows what they're doing and they're intentionally walking their lines. And that's why I'm asking, is there nothing else there that we can implement?
What about the advertising? I mean, if he's advertising as a real estate firm, and he
What about
is,
the full name?
and is this website advertising as a real estate firm still up and operational?
Last I checked, it was.
So he's still operating
Actually-
a website?
I'm sorry, they sent me a printout, the complainant sent me a printout of it. I had a hard time finding it based on the address. I'm wondering if it's through a renter log-on that this information's there, because when I tried typing in the address that was at the bottom, it wasn't taking me to the same place. But I have printouts from the complainant that says this, so I do have proof that there was, I could not access it, but I think it was because this complainant had access privileges that I don't, because I'm not a renter of the company.
I move that we take your recommendation, but that we also flag this individual as filing so that when they come out of retirement, we'll know to watch them. At least there'll be some notation in that individual's file, and the consent order make reference to them ceasing and desisting this kind of action.
We have a motion by Commissioner Northern to take council's recommendation, but to add to that recommendation that we flag this file in case this individual ever reactivates his license, and it has been seconded by Commissioner Alexander. Any other discussion? Commissioner Drees?
The motion also included a cease and desist language of some sort as well, correct?
Cease and desist, yes, Commissioner
Would
Drees.
this not also fall under 62-13-312-1, making any substantial and willful misrepresentation?
Robin, I might ask you on this in case this were to go to litigation, because I think that would be,
Yeah. The problem I have is it's not against, is it against this individual?
it's against the individual.
Who's in retirement?
Who's in retirement? Yes, it's a licensee that's got a retired license.
Better? No, okay. I can't say, I think your strongest thing is the management, properly managed without a license, because it's really, it's convoluted. I think it's weak on that particular point. I think Julie picked the strongest violations that we're comfortable pursuing.
I guess my concern is that this person's going to continue to do this, or going to come back in with the blessings to proceed.
Well, the problem we have with anything that is not typically licensed, I mean, he could lose his retirement license from retirement. and he could still continue it, and can we do anything about that?
No, because we
Right.
don't have enough teeth.
Well, because we don't have enough teeth.
Any other discussion on the motion? Hearing none, all in favor say aye. Opposed, no. I'd like to add one thing. Y'all need to realize and never forget that we are operating under the open meeting law, and everything that is said needs to be heard, so we'll have a permanent record of it. So just talk into these microphones and make sure we have a record of everything that we say.
Sorry.
Speak up. And at this time, we're going to take a 10-minute break. I'd like to call this meeting back into session, but I also would like to remind all you licensees out there, those of us up here who are in the real estate business, the industry members who are here today, and there's 6 of us here, we have busy schedules just like all of you. At break, I return phone calls. And those of you who have your laptops out there, turn them off, close them up, and pay attention, because you're here to get 8 hours of continuing education. And at break and at lunch, you can conduct whatever business that you need to conduct. But I just want to remind you to turn all those things off while this meeting is in session. And then at break and at lunch, you can attend to matters at work. With that in mind, I turn it back to you, Ms. Crop.
Number 12, 2012-008661. A complaint opened by Track based on information received soon after respondent, an affiliate broker, submitted an application for a broker license. In respondent's 2012 application for broker license, respondent responded no to the question of, have you ever been refused a license or had a license revoked, suspended, reprimanded, or fined by any federal, state, or local government, do not include motor vehicle license, and also answered no to the question of, have you ever had a complaint filed against you with any regulatory agency or with any court. Respondent also answered no to these questions when respondent replied for respondent's affiliate broker license in 2008 and 2005. TREC received information that in 2004, respondent entered into a consent order with a regulatory agency within the state whereby respondent's pending application for registration with that agency was denied based on dishonest or unethical business practices, and respondent was ordered to cease and desist respondent's activities and was permanently prohibited from applying or seeking registration through that agency and was prohibited from applying for licensure administered by and or handled through the Department of Commerce and Insurance. Via email, respondent acknowledged receipt of complaint but did not submit a response. At this time, respondent has passed the broker's exam and submitted an application for a broker's license, which is on hold due to respondent's failure to disclose this information. The recommendation is a consent order for denial of respondent's broker license application and for voluntary revocation of respondent's affiliate broker license based on the respondent's substantial and willful misrepresentations on respondent's 3 license applications with the Commission in violation of Tennessee Code Annotated Section 62-13-312B1 and respondent's failure to respond to a complaint filed with the Commission in violation of Tennessee Code Annotated Section 62-13-312B14 and 6213-313A2.
Motion to accept council's recommendation.
Second.
I have a motion by Commissioner Collins and second by Commissioner Northern to accept council's recommendation.
Question. Julie, is there any penalty we can impose in addition to revoking the license since this person has had a license for so long based on a false representation?
Robin, I haven't ever encountered that before. It's voluntary revocation. The consent order would be for denial of the application and voluntary agreeing to have the license revoked.
I think if you weren't going to do it, if you weren't going to, I thought you could hear me anyway. I'm very sorry, Chairman.
We can, but they can't. The record can't.
Okay, sorry. I think you could do, if because you're asking him to voluntarily surrender, I don't think you'd stick a civil penalty on top of that and get away with that. The punishment really is getting rid of his license at this point. If he does not comply, you certainly can have a trial without to not only revoke and do a civil penalty based on continuing actions of that part. Now, failing to report,
Respond to the
Yeah.
complaint, failing to respond.
okay,
to the
now,
complaint.
he did tell you about the criminal, well, we don't have the criminal activity, do we, the entire conviction? Do you?
We have a copy of the consent order, which shows that there was a complaint filed by another regulatory agency, which means there was misrepresentation on one question, and that there was discipline assessed there. We have a copy of that consent order. We received that anonymously, so.
And basically what you're doing is you're doing the civil penalty based on his failure to comply with that order, which says he can't have a license.
No, it's on his misrepresentations on 3 licenses.
Yeah, but it's because he was told he wasn't supposed to do this in the other order too, though, right? That was part of it.
Right, but it's really just because he said no, that he had not been disciplined.
Yeah, I don't know that you can do money on, I mean, you can try, but I don't think you're going to get it. I think the penalty is going to be, if he accepts it, the penalty is going to be giving up his license.
Does that answer your question, Commissioner McMullen?
Yeah, I don't like it, but
Okay.
previous question.
Question's been called on the motion hearing. All in favor say aye. Aye. No, motion carries.
Number 13, 2012-009481. Complainants are the owners of property who entered into a rental management agreement with respondent, an unlicensed entity. Complainants state that respondent failed to provide accounting statements or rent checks for a period of several months. Complainants state that upon researching respondent, complainants found that respondent does not hold a firm license with TREC and is not licensed with the state as an LLC as stated in complainant's rental management agreement with respondent. Complainants attached a copy of the contract as well as a letter from complainants to respondent terminating the rental management contract and copies of the rental calendar for complainants' property showing the rental bookings for the months for which complainants have not received rental payments. Respondent submitted a reply in May 2012 stating that a check has been sent to complainants for the rental proceeds owed to them. Respondent also states that it is an out-of-town company that manages hotels and was asked to take over the management of the resort, and respondent was unaware of the new VLS laws and received incorrect information from an attorney, resulting in respondent not being filed correctly with the proper authorities. The individual responding for respondent states that he has taken the course to be the designated agent and all employees mentioned within the complaint have been released and training of a new management team is in place. Respondent asked for 30 days to fix the problems. It states as of July 25, 2012. I checked it again yesterday on August 7th. It does not appear that respondent has applied for a VLS firm license. The recommendation is a consent order for $1,000 for unlicensed activity in violation of Tennessee Code Annotated Section 62-13-104B2.
Move to adopt council's recommendation.
Commissioner McMullen has made a motion to accept council's recommendation. It's been seconded by Commissioner Collins. Any discussion on the motion?
Back to the cease and desist
We can add that as well.
until they get a VLS license. I think
Typically, the language always goes in there that they shall comply with all the rules, but I think in this case, we can certainly add it to more clearly state you shall cease and desist this, so.
I'd offer that as an amendment, Mr. Chairman.
Commissioner Grease wants to add cease and desist as part of the recommendation that we're voting on.
And I'll second that.
We're just going to add it as a friendly amendment.
I'll accept that.
He accepted it. Commissioner McMullen, I knew he was going to accept it. All in favor of the motion as friendly amended?
Aye.
Say aye. Opposed, no. Motion carries.
20120098861. Complainant is a licensee who was contacted by an individual from another state notifying complainant that the individual suspected that a scammer was using complainant's name and license number and directing people to search the license online to solicit timeshare purchases. Complainant attached a copy of an email from respondent referencing the process and including complainant's name and license number as well as the name and license number of another licensee. Complainant also attached a copy of the letter guaranteeing to the recipient a purchase of the recipient's timeshare. It includes a signature, which is supposed to be that of complainant, and includes an address and phone number in Tennessee. A copy of the complaint was sent to respondent via certified mail at the address provided on the correspondence from respondent, which was returned with the notation of return to sender, no such number, unable to forward. A TREC auditor confirmed that there is no office at the address provided on respondent's materials. Therefore, the recommendation is to refer this to the district attorney's office, and we can flag and close it. But
Move to adopt council's recommendation.
Motion has been made by Commissioner McMullen and seconded by Commissioner Northern. Take council's recommendation, refer to district attorney's office and close and flag the file. All in favor say aye. Aye. Opposed, no. Motion carries. Number 15.
2012-009-701. Complainant submitted a copy of an indictment against respondent, an affiliate broker from a federal court in another state, and stated that respondent pled guilty in 2011 to one of the charges. Complainant says that respondent's license should be revoked based on the guilty plea. Respondent submitted a response stating that the parties are currently in litigation, which is the reason for complainant's complaint. Respondent denies that respondent has been or will be convicted of a felony and therefore sees no reason for discipline of respondent's license. Based on information received from the U.S. Attorney involved in respondent's case, respondent entered a guilty plea to a felony charge, but respondent has not been convicted and will not be convicted until sentencing after the trial of the remaining defendants at which respondent is supposed to testify. Until after the trial and sentencing, respondent's guilty plea can be withdrawn if respondent elects to do so. Based on the fact that respondent has yet to be convicted of this felony charge, there does not appear to be, at this time, a basis to discipline respondent's license under the provisions of the Broker Act, and therefore the recommendation is to dismiss.
I'm going to flag that file. We're going to call up and see if there's a conviction.
I can do that.
Then if there is, then there is a... Then if there is a complaint.
Right, and there is a requirement in our statute that we be notified by that respondent within 60 days. Otherwise, there's an automatic revocation of the license.
I will take council's recommendation based on the eventual information that she has added that will be put to the file.
I have a question. With regards to the statute and the way it's worded, it says pled.
What's the crime that he was accused of pled guilty to?
It's a felony charge I confirmed with the U.S. Attorney. I get very limited information because the documentation of this file is currently under seal, and so they could not provide me with very much. All I had is what the complainant gave me. I can't obtain anything else at this time. But it appears to be a...
Stated that he had already pled guilty.
There is a minute entry in there stating that the guilty plea was given, but I spoke with the U.S. Attorney and said it's basically being withheld and has not been deemed a conviction until after this person testifies.
It doesn't say that he has to be convicted. It says that he has to.
The one on, are you talking about 312F, the whenever a licensee pleads guilty? It does say whenever a licensee pleads guilty or is convicted, it says the licensee must, within 60 days, notify the commission of that conviction. It requires notification of the conviction. Here, there has not been a conviction yet. So I think we would have a hard time showing that he had the duty to notify yet because it has not been accepted, it has not been deemed a conviction yet. It's just kind of a guilty plea that's being withheld at this point.
But Section 6213.312B12 says that
it's again convicted.
But then it says, or pleading guilty or nolo contendere to any such offense or offenses. And F is just the disclosure requirement that you've got to self-report whenever you get convicted. But he still violated 12 already by pleading guilty. He may not have had a disclosure obligation yet.
I
It
do.
says-
I think
and
that it refers to specific types of convictions, and we don't have that information.
I do.
But then it says, or any crime or any similar offense or offenses.
And it is a felony, which I do know that. And so I believe
We had a big discussion on this until it is not unlike, this is not unlike the situation where you have a person who has pled guilty, that we had that discussion with the district attorney that one time, whose conviction can be expunged and there is no conviction. It is not unlike that situation at this particular point. Until the final act where it becomes fully of record and we have a copy of convictions, which we don't. The only thing that Julie was able to get was a notation in the minute, no copy of any conviction.
It doesn't say that he has to be convicted. It says pled, and if 60
But there
days
is no-
has
but
expired
there's
from the time he pled,
But
then he's
Commissioner
required
Northern,
to report it.
there is no conviction until it's entered as a conviction, as a plea, and it's not been entered in the court's documents at this point, so there isn't anything yet.
I think that in this case, the notification F, that the way it is is worded is that there has to be notification of the conviction. So I think we would have a hard time under F, automatically.
But I think, well,
Change the wording because it's misleading the way I understand it.
I think we can revoke it now because 6213.312B says the commission shall have the power to refuse a license for cause or to suspend or revoke a license where a person is found guilty of, and then it says being convicted of a number of crimes, and it says or any crime or any similar offense or offenses, or pleading guilty to any such offense or offenses. And so I think the pleading guilty to any crime is enough to revoke. F just talks about you got to disclose your obligation and an automatic revocation that occurs after the conviction, but I don't think that prohibits you from going ahead and revoking it before the 60 days.
I think it does.
B12.
It does. Traditionally, it has only been,
You didn't, it was not a second anyway, it's dead.
Before somebody jumped up and seconded that one.
I think under 12, B12 here, if we were to take action, including revocation, in that case it would have.
What, which,
I'm sorry, 312, subsection B12. That's confusing. It starts with being convicted in a court of competent jurisdiction. Do you see where I'm talking about? And I think under that one, if we were to use that as a basis for revocation or any other action, it would have to go through a consent order and a hearing. I think it would be difficult to automatically revoke based on that section because it doesn't state automatic revocation. Subsection F does provide for automatic revocation, but I believe based on the way it's worded that they would have a strong argument, because we're talking about revoking someone's license, automatically revoking someone's license here, that there is not yet a conviction, and by the strict reading of the statute here, it would be very difficult under F, and I believe there would be significant challenge from this person, and with the wording it would be something substantial to overcome. B12,
I think if the commissioners feel that there is a violation and it falls within our interpretation of the law, that we move forward, and if it's challenged, it's challenged. That's why we have legal counsel.
Norton, I'm waiting for you to make a motion.
I move that we...
can I ask one more question? Julie, under F, which you are reading, it says whenever any licensee pleads guilty, then he's got 60 days. Do we know the date that he pled guilty according to the minute?
the minute entry does give a date of that, and it is over 60 days. But where I'm reading down is, must within 60 days notify the commission of that conviction. And here, there's no conviction yet, but we do have the date of the guilty plea. Yes, I do. It's a minute entry. There's an online docketing for federal cases, and you can access the documents by clicking the links. In this case, I cannot get to those documents because they're under seal. But there is a minute entry which provides just a summary that there was a guilty plea entered.
But what Julie's saying is that under that F, it's poorly written because it said the disclosure obligation arises whenever you plead guilty or are convicted. But then what you actually have to disclose is that you were convicted, and he hasn't been convicted
That's
yet.
where
So
it's-
but that's only on the disclosure
That's on-
obligation. I still think we can revoke under B12.
You'd have to have a hearing for that.
I know. Well, I think my motion is that we offer the person a consent order of revocation.
To volunteer like the other one.
Yeah.
I think it's definitely.
Second the motion.
Have a motion by Commissioner McMullen and seconded by Commissioner Northern that we offer this individual a voluntary surrender.
Surrender?
Yes.
Or
Voluntary
revocation.
surrender.
Surrender. Yeah, that's fine.
Is that would you, is
Not
that,
the right word? Yeah.
is that what you were making your motion on?
Yes, sir.
And we have a second by Commissioner Northern. Any discussion on the motion? Commissioner Grease.
Okay, so if he doesn't voluntarily surrender based on this motion, then where are we?
We go to a formal hearing.
Well, we have to institute a formal hearing at that point?
Yes. Let me explain where you are in the formal hearing process. It'll be next year sometime before it can be heard. Let me also explain, and while I understand your concerns, I really do. Let me also explain that if because of the dynamics of this particular set of circumstances, if he were to challenge it, and I don't know if he's going to or not, but if he were to challenge it and had a competent attorney, my suspicion is that they might ask Chancery Court to find this capricious and arbitrary because of the dynamics of the language of the statute and the dynamics of this particular conviction. And if that were to happen, then just to let you know, I mean, you know me, I'm very aggressive in trials, so you know I'm going to be aggressive. But if that were to happen, it can lead to individual liability. Just to give you the heads up on all of it. That's because I'm not that confident. But it won't be till next year.
Because we choose to follow the statute.
Well, see, the statute's ambiguous in some of that. That's my point.
So that's not our fault.
But it is our responsibility.
But in F, I can understand F being ambiguous, but under 12, that is not.
Well, but the problem, just understand in this particular set of circumstances, and it's just this particular set of circumstances, what we have is a notation alone. We have no copy of any conviction or any plea. It was not available to us. We have a notation in the minutes. We can't substantiate that or anything. We can't do it. It won't be provided to us. If we had a document that showed that, we'd be in a different position, but we don't. And that's why I was saying that in this particular set of circumstances. And because the dynamics surrounding this particular plea, which apparently he's agreed, and they're holding it all in abeyance because he's agreed to testify against other people, and because he can withdraw this plea at any time, that it isn't anything final. That's our concern. That's why Ms. Kropp had recommended what she recommended. And not that you don't follow up with it, but where it is in the status right now.
The question again. It's 3 times I've called the question.
I've been ignoring you.
I'm very confused. I believe proper protocol is to vote.
Question has been called. Steve Maxwell, call the roll.
The motion is to issue a consent order for voluntary surrender of the license. Is that correct?
Correct.
Okay. Alexander?
For the motion.
Collins?
For the motion.
DeChara?
Yes.
Grease?
No.
Flitcroft absent. Haynes absent. McMullen?
Yes.
Northern?
Yes to the motion.
Stevenson?
No to the motion.
The motion carries 5-2. 5 yes and no.
Number 16 and 17, Mr. Cook.
16 and 17, 2012-009771 and 2012-009781. Both complaints are opened against this respondent, an affiliate broker, based on the complaint of an individual who entered into a lease agreement with respondent. Complainant alleges that complainant gave respondent a security deposit security deposit check at move-in, and after moving out with no walkthrough, complainant never received a return of the security deposit. Complainant states that when asked about the deposit, respondent stated that respondent had given the deposit money to the owner and the owner had decided to keep the deposit due to alleged damages. Complainant disputes any damages and states that respondent has not explained why the deposit was not kept in an escrow account or explained exactly why the owner decided not to return the deposit. The second complaint was opened because, based on the complaint and the lease agreement provided by a complainant, it appears that respondent, while affiliated with a real estate firm, was also managing residential property through another company on the side. Respondent submitted a response stating that the owner of the subject property had listed the home with respondent's real estate firm for a period before deciding to rent. The complainant entered into a lease agreement with respondent through respondent's other company and paid the security deposit to respondent. Respondent states that the owner then instructed respondent to give the security deposit to the owner. The lease agreement does not state the security deposit was to go to the owner. Respondent states that respondent collected rent and passed it all on to the owner, who was merely trying to help out a client with hopefully a later reward of listing the home for sale. At move-out, the owner did a walkthrough and told respondent there were damages greater than the security deposit amount, and the owner was keeping the deposit. The owner prepared a damages list but would not give the respondent permission to provide the list to complainant due to litigation threats. Respondent provided the list and also stated that complainant had a dog on the property without the owner's knowledge and no pet fee was paid. Respondent states the complainant did not ask about the damages list or walkthrough, but only threatened litigation. As to the complaint regarding an unlicensed property management firm, respondent admits acting as a property manager for a small number of clients over the years, but states that most of these services were performed without any direct fees or consideration for the services other than the hope of a future listing. As a result of the complaint, respondent states that all future security deposits will be held with respondent's broker and all current security deposits will be transferred to respondent's broker. All rents be made payable to respondent's firm and all documents will reference respondent as an affiliate broker with respondent's firm. Complainant submitted an additional response that disputes the list of damages prepared by the owner and the statement regarding the owner's knowledge of the dog, and complainant restates that complainant did ask about a walkthrough in the damages list. The recommendation is a consent order with a civil penalty of $1,500 for failure within a reasonable time to account for or to remit any monies coming into the licensee's possession that belong to others in violation of Tennessee Code Annotated Section 62-13-312B5 and 14 and 62-13-4036 and Rule 1260-02-.091 requiring that rental deposits must be held in separate account, and for operating a property management firm without a license in violation of Tennessee Code Annotated Section 62-13-312B14 and 62-13-309A1A, which requires each office to have a real estate firm license, a principal broker, and a fixed location with adequate facilities for affiliated licenses. And Rule 1260-02-.011, which states that no licensee shall engage in any real estate activity in any office unless there's a principal broker who devotes his full time to the management of such office, plus attendance at a 2-day meeting of the Commission within 180 days of respondent's execution of consent order.
Question. Does your file in any way indicate that the broker had knowledge that this affiliate was doing this?
The following complaint is opened against the broker. The information we have is that the broker did not have knowledge of it. And when made it.
I move to accept council's recommendation.
Second.
Motion by Commissioner Northern to accept council's recommendation and seconded by Commissioner Grease. Any discussion on the motion? Hearing none, all in favor say aye. Aye. No, motion carries. Number 18.
2012-009801. Track open complaint against respondent, principal broker of the previous respondent, for failure to supervise based on the facts above. Respondent submitted a response stating that until a copy of the complaint was received, this respondent had no knowledge of the previous respondent's residential rental activities, as these activities were not conducted through this respondent's firm, and no security deposits or commissions from this rental activity was received by this respondent's firm, but through the previous respondent's side business. This respondent submitted a copy of the independent contractor agreement between the previous respondent and this respondent's real estate firm, which stated that the previous respondent was to conduct all real estate business through the firm. This respondent states that when the complaint was received, this respondent instructed the previous respondent to cease and desist these rental activities unless done through this respondent's firm. Based on this information, it appears that the previous respondent's rental activities were concealed from this respondent, and upon learning of these activities, this respondent instructed the previous respondent to cease the activities unless performed through the respondent's firm.
Second.
I have a motion from Commissioner Northern to dismiss and seconded by Commissioner Grease. Any discussion? All in favor say aye. Aye. No, motion carries. Number 19.
2012-009881. Complainant was a potential buyer of a property listed by respondent, an affiliate broker. Complainant states that after viewing the property, complainant's agent called respondent to inform of an offer and emailed the offer that afternoon before 5:30. Complainant states that respondent was informed the next morning that the property was already under contract. Complainant states that respondent's spouse's client was the purchaser. Complainant states that neither complainant nor respondent's agent were aware that there were multiple offers or complainant would have made a full price offer. Respondent submitted a response with documentation. Respondent denies that respondent's spouse's client was the purchaser of the home and states that none of the potential buyers were brought by respondent's spouse. Respondent attached copies of all 3 offers received on the property to confirm this. Respondent also provided a copy of emails confirming that all offers, including complainants, were presented to the sellers. Respondent states that though complainant's offer came first, it had multiple contingencies, and a second offer received was an all-cash offer with no stipulations. Respondent states that respondent was instructed by the sellers to decline complainant's offer and proceed on negotiating with the second offer, and respondent attached an email to complainant's agent reflecting this. Said email did not state that the property was under contract, but that the seller had chosen to work with and negotiate the other offer based on its strength. Respondent states that in the end, the potential buyer with the second all-cash offer and the seller were not able to come to an agreement, and the offer was terminated, with the sellers choosing to accept a third written offer, which was closer to the list price with no stipulations. Respondent included a letter from the seller confirming Respondent's version of the events. Based on the information contained within the file, there appears to be no violation of TREC statutes and/or rules by Respondent, and therefore the recommendation is to dismiss.
Second.
Motion to dismiss made by Commissioner Collins and seconded by Commissioner McMullen. Any discussion? All in favor say aye. Aye. Opposed, no. Motion carries. Number 20 and 21.
2012-010-311 and 2012-010-312. Complainant met with Respondent 1, an affiliate broker, and states the complainant signed a one-page authorization form authorizing Respondent 1 to act as complainant's agent. Complainant states that Respondent 1 submitted an offer on the property on behalf of complainant. Complainant states that the complainant was never provided with copies of the documents that complainant had signed. Complainant's offer was not accepted, and Complainant 2 made subsequent offers on other properties. Complainant states that after being dissatisfied with Respondent 1's services, Complainant contacted Respondent 2 principal broker to ask for a copy of the buyer's representation agreement, which was sent. Complainant states that it is not Complainant's signature on the buyer's representation agreement. Complainant wants to be released from the buyer's representation agreement. Respondent submitted a reply stating that Complainant was looking to purchase a HUD-owned home, and Respondent 1 put Complainant in touch with a lender and showed Complainant a number of homes. Respondent 1 supplied documentation showing that Respondent 1 stayed in close communication by email with Complainant and submitted a number of offers on behalf of Complainant. None of the offers appear to have been accepted. In the weeks that Respondent 1 represented Complainant, Respondent 1 states that copies of these documents were provided to Complainant. Respondent state that Respondent 1 represented client to the best of Respondent's ability and did nothing improper, but Respondents determined it was best to release Complainant from the buyer's agreement. Respondent 1 composed an email to Complainant sent one day after the Complainant filed this complaint with TREC with a release agreement which was signed in return. Based on the information contained within the file, there does not appear to be a violation of TREC statutes and/or rules by Respondents, and therefore the recommendation is to dismiss.
What's your pleasure?
I have one question before. So the complaint states that it's not the complainant's signature on the buyer representation agreement. How did the Respondent address that?
The person basically said, we signed all these documents. I don't understand, I'm not his signature. She provided all of the documentation signed and said, as you can see, these signatures vary. This is this person. She basically denied doing it, and I can't tell. I'm not a handwriting expert. I can't tell from that there was. It appears that the complainant wanted to be released from the agreement, and that was done. And based on my review of it, I cannot tell. It's one person's version of events versus the others.
Well, the complainant says they signed a one-page buyer representation agreement. Then when they got a copy of it, they said it wasn't their signature on it. I'm okay with everything else about it, but if somebody's forging signatures just to fill a file, which I think real estate agents do occasionally,
Well,
just
and
a
like
guess.
I said, there was a denial there, and when the response was received, usually complainants will come back, and we didn't receive anything further on this one. And like I said, this was going on where the person was released from their agreement one day after the complaint was filed before the respondents had notice of it. I'm assuming that this person was released from the agreement and was satisfied with that because we received nothing further after this to follow up on what they said. I just can't tell, like I said, from it.
Again, I asked the question, what's your pleasure?
Motion to dismiss.
I have a motion to dismiss by Commissioner DeShara. Did I hear a second? Second. Second by Commissioner Northern. Let's go to any questions or any further discussion. Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 22.
2012-010-721. Complaint opened by TREC against Respondent Affiliate Broker for Respondent's failure to satisfy an agreed citation sent to Respondent for failure to timely complete administrative steps. Based on the information in the file, it appears that Respondent was broker released by Respondent's previous broker in 2011, as shown in a completed TREC 1 form received in August 2011. At that time, Respondent was sent a letter advising that Respondent had 10 days to either retire Respondent's license or to transfer to another firm. Respondent submitted a TREC 1 firm affiliating with Respondent's current firm in May 2012. Respondent was sent a copy of an agreed citation for failure to timely take administrative steps, which Respondent signed for in May 2012. To date, Respondent has not responded to or paid the agreed citation. Therefore, the recommendation is a consent order for $300 for failure to timely complete administrative measures as required by the Commission for either change of affiliation or retirement in violation of Tennessee Code Annotated Section 62-13-312B 14 and 16 and Rule 1260-02-.02 subsection 2, plus attendance by respondent at a 2-day meeting of the Commission within 180 days of respondent's execution of consent order.
Heard the recommendation of council. Your pleasure.
I'm sorry, I've got one more question.
Mr. Greaves.
So the agreed citation that was originally sent, how many dollars penalty was on that?
It was $250.
It was $250.
Yes, it
And
was.
he didn't pay or she didn't pay the $250, and now we're saying, you owe us another $300. So the total is $550?
No, it would be the way I understand it's $300 instead of the $250. It is moved up to when they don't respond to the agreed citations, the staff opens them in legal, and then it is now that consent order instead of the citation. So
What's the maximum you can find?
let me check it. I believe it's 1,000.
Let's get their attention.
The maximum for subsection B16 is currently appears to be $750. This is a statute that's up at the AG's office right now. I mean, a rule that's up there at the AG's office to be revised. Right now, it appears to be $750 for that, but we also, they are written for a rule which, under B14, which that's violation of any statute, that is a maximum limit of 1,000 there. So
So that could be $1,750.
that would be, but if you do the maximum under both of those statutes, that's what it would be.
My motion is to accept council's recommendation with the Reeves to find $1,750.
They signed for it.
We have a motion by Commissioner Alexander to send order for $1,750. Failure to timely complete administrative measures required by the commission and all the other stuff that goes there. The balance of that recommendation made by council to changing the $300 to $1,750. Do I hear a second? Somebody like to amend Commissioner Alexander's motion?
I'll second it for purpose of discussion.
Okay, we have a second by Commissioner Grease.
So,
Discussion.
if they didn't pay $250, they might not pay $1,750, at which point you'll come back to us with,
It'll go to litigation. Whenever they choose not to accept the terms of the consent order, which is being offered by the commission, after 30 days, it's transferred to litigation and put in line to be put before the commission on a formal hearing.
so during that period of time, they're still practicing.
Well, this person is, they are affiliated with a broker right now. They just did not do it within the time constraints. They are properly licensed and affiliated with a broker currently. It's just that was not done within 10 days.
Well, I understand Mr. Alexander's point, but for failure to just do some administrative work, it might be a little tough.
Would somebody like to amend Commissioner
I'll
Alexander's motion?
I'll amend it to change the number to 500.
I'll second that.
We have an amendment on the floor to Commissioner Alexander's motion of $1,750 to $500, and its amendment has been made by Commissioner McMullen and seconded by Commissioner Northern. Any discussion on the amendment? Hearing none, all in favor say aye.
Aye.
Opposed, no. Now, we're voting on the original motion as amended. The recommendation would be $500, consent order for $500 instead of the $1,750. Any discussion on the motion as amended? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Next.
I have a question, please, which might include Ms. Wright. We changed all of our penalties to $1,000 some time ago, and we sent them up. I thought the AG's office had already approved all of that.
You have to ask Julie that.
They're currently at the AG's office, and they're not effective, I understand, until, once we get approval from the AG's office, they then go to the Secretary of State's office. They're not effective once they have been on file with the Secretary of State's office for a period. So at this point, those rules are not yet effective.
July 1st.
I do recall there were maybe a couple that we had overlooked. Is this one of those 2 or 3 that we overlooked?
What do you mean? I'm sorry.
We had sought to make everything uniform, we brought it up to $1,000.
It is. It is on the pending rule. It's just it's not effective yet, and so we can't.
You better go make him reservations.
Do you want me to, when you first did all the VLS rules, and these were combined in those like 2 years ago, there was, we went through the public hearing. That's I think what you recall. Went through the public hearing, and those rules went to the AG's office in 2011. After the legal department chief counsel, is that what Wayne is? Deputy General Counsel Pugh looked at all the background. They actually stayed in the AG's office for a long time, and when Mr. Pugh looked at those, he had determined that perhaps the Financial Regulatory Flexibility Act had not been examined closely enough in December of 2010 prior to the public hearing, which was held in February 2011, I think. So in any event, those were withdrawn with the vacation lodging rule. So every rule that was sent over at that time was withdrawn, and the rules that you all just heard this year then included those, and those had gone over to the AG's office. So you're correct that you all did pass a rule that would have done that, but it never got out of the AG's office, that whole set of rules. And that's why they broke them into 2 sets this year when they sent them over. The ones that dealt with the absence of the PB and the uniformity of the penalties.
Passed out a sheet that showed that these new penalties were now in place.
We passed out, well, there was a sheet that, or someone had in their book written in the statutes so that it would line up, so that the ones that are in there now, some of them don't line up. This may be one of the ones that, some of them just had they weren't in line with their proper, the proper ones, because the numbers had not been changed through the years when some changes had been made to the disciplinary rules. This may be one that was not the case with, but they're all over there right now to make sure that they're uniform at $1,000. And I know what you're talking to, because we've taken it to the judge a couple of times and said, here's the correct penalty amounts. That's so I don't know where that one falls in that situation. Right.
Roberts to realign. I think that's where that.
Okay, so that fell outside that realignment, as it were.
Commissioners have a copy of what we actually have.
The authority to do right now.
Or not in
The proposal is good.
the binder.
Yes.
But there is no listing of penalties applicable to each statute.
Like what that's drawn out. That's
It's thrown out like in the manual.
I probably not. If it's
Somebody put one together.
we could put one together and do that. Yes. Hopefully the rules will be soon, but yes, we can definitely do that.
I'm operating under the assumption that it all in change. Mr. Chairman.
Have we finished with this discussion? You finished. Number 23 and 24.
2012-011-791 and 2012-0011792. Complainant attended a timeshare presentation and purchased a timeshare with respondents. Respondent 1 is a firm and Respondent 2 is a timeshare registration. Complainant alleges a number of verbal misrepresentations on the part of Respondent's representatives, including the length of the presentation, the length of the cruise which was promised for attending the sales presentation, selling the timeshare back, and the timeshare increasing in value, payment for attendance at an orientation would be reimbursed. Later found out that the reimbursement was dependent upon bringing a guest and failure to notify of the contract cancellation period. Complainant provided contracts and related documentation and wants the timeshare contract canceled. Respondent submitted a reply stating that potential purchasers are only required to stay the stated period of time, but sometimes stay longer based on interest in buying. Further, respondents deny any verbal representations and point to documents signed initial by complainant which address the various issues raised by complainant. As to the orientation, respondents claim there were no misrepresentations regarding bringing a friend and payment to the complainant for doing so, and point to materials outlining the offer. Respondents denied complainant's request for contract cancellation due to the request being outside the period specified within the contract the complainant signed. Based on the information contained within the file, there is no evidence to substantiate a violation of TREC statutes and/or rules by respondents, and therefore the recommendation is to dismiss.
Motion to dismiss.
Second.
We have a motion by Commissioner Collins to take council's recommendation to dismiss, and a second by Commissioner Shara. Any discussion? All in favor say aye. Opposed, no. Motion carries. Number 25, 6, and 7.
2012-011-881 and 2012-011-882 and 2012-011-891. Complainants were owners of a timeshare in another state and met with Respondent 1, timeshare salesperson, while on vacation at a resort in Tennessee. Respondent 2 is the timeshare registration, and Respondent 3 is the principal broker. Complainants state that Respondent 1 made verbal misrepresentations, including telling complainants that they could switch their week system to a point system with Respondents, that their existing timeshare was switched to the resort complainants were staying at in Tennessee, and that complainants would get back their maintenance fee for the year paid for their existing timeshare and their transfer fee. Further, complainants allege that Respondent 1 verbally misrepresented the perks of Respondent's rewards program. Complainants allege that after the presentation, Respondent 1 did not answer their telephone calls. Additionally, complainants allege they were unaware of the contract cancellation period. Respondents submitted a reply attaching signed documentation relating to the subject sale. Respondents deny any verbal misrepresentations, pointing to documentation signed and initialed by complainants indicating understanding regarding Respondent's point system program, which states that this is a one-time annual exchange and does not represent a timeshare ownership conveyance, as well as the rewards program, which states that the discounts and benefits are subject to conditions of the suppliers of the benefits. Respondents also reference the signed initial statement of understanding. This contract includes a provision regarding the cancellation period. While respondents denied any inappropriate activity, respondent states that they are in agreement with cancellation of complainant's contract due to apparent misunderstanding. Based on the information contained within the file, there is no evidence to substantiate a violation of TREC statutes and/or rules by respondents, and therefore the recommendation is to dismiss.
What's your pleasure?
Motion to dismiss.
Shara makes the motion. We just take council recommendation to dismiss. Do I hear a second?
Second.
Second by Commissioner Grease. Any discussion? I'm learning to differentiate between the two. Hearing none, all in favor say aye. Aye. No, motion carries. 28, 29, 30.
2012-011-2771, 2012-012-2772, 2012-012811. Complainants were timeshare owners who met with representatives for respondents. Respondent 1 is a timeshare registration, Respondent 2 is a firm, and Respondent 3 is the principal broker. Complainants want a contract cancellation based on alleged misrepresentations on the part of Respondent's representatives, including purchasing a program to upgrade the complainant's points level whereby maintenance fees would stabilize. Complainants would not have to pay high property taxes and no special assessments. Complainants also state that they were told they would have a personal account manager, that they would have no payments the following month and could refinance with their bank. Respondents submitted a reply stating that complainants have been owners since 1989 and have made 6 additional purchases prior to the subject purchase in 2011 in Tennessee. According to Respondent, complainants traded in their existing contracts to upgrade to an ownership plan, providing complainants with VIP status. Respondents point to documentation signed and initialed by complainants to show that the date of the first payment was specified in terms of the membership complainants purchased. Respondents deny any misrepresentations and state that the terms of the purchase were specified in the documents signed by complainants. Further, respondents state that the complainants have continued to use their ownership. Based on the information contained within the file, there is no evidence to substantiate a violation of TREC statutes and/or rules by respondents, and therefore the recommendation is to dismiss.
Heard council's recommendation.
Move to accept council's recommendation.
Second.
Commissioner Grease makes a motion to accept council's recommendation and dismiss, and it's seconded by Commissioner DeShara. Any discussion? All in favor say aye. Aye. No, motion carries. Number 31 and 32.
2012-013981 and 2012-013982. Complainant was an existing timeshare owner who attended a sales presentation in Tennessee in 2011 with respondents. Respondent 1 is a timeshare registration and Respondent 2 is a firm. Complainant and friends listened to the sales presentation and indicated frustration with the monthly costs and use of points. Complainant alleges that respondent told complainant about a program which at no cost would provide a personal representative to oversee the account and would reduce maintenance fees, so complainant signed a contract. Several months later, dissatisfied with the assistance provided in the program, complainant requested cancellation and refund, which was denied. Soon after, complainant and friends attended a presentation in another state where complainant again indicated dissatisfaction with the costs and program, and complainant was persuaded to sign up for a second option with more points with a bill me later option. Later, due to dissatisfaction with the second program, complainant asked about canceling the contract and was told no. Complainant wants cancellation of both contracts. Respondent submitted a reply stating that complainant has been an owner since 2005 and has made multiple purchases since that time. Respondents deny any misrepresentations or wrongful conduct in attaching documents.
Move to dismiss.
We have a motion to dismiss this complaint by Commissioner Northern and seconded by Commissioner Collins, I think. Any discussion? Hearing none, all in favor say aye.
Aye.
Awful weak. All in favor say aye.
Aye.
Opposed, no. Number 33. Thank you.
201201231. A complaint opened by Trek against respondent, a timeshare salesperson, for failure to timely complete administrative measures. It appears that respondent was broker released and did not affiliate with a new broker until almost 5 months later. Respondent was sent an agreed citation, which included a civil penalty for this violation, and because respondent had not signed and returned said agreed citation, this matter was opened in legal. Soon after this matter was opened in legal, in response to the complaint, respondent executed the agreed citation and paid the civil penalty included therein, and therefore the recommendation is to dismiss.
Where's his license now?
What do you mean where?
They
are
does he have an active license now?
and it is affiliated with somebody. It took 5 months for the change to take place.
Okay, but we didn't like that earlier.
That person did not respond to the agreed citation. This person paid. It's just after the file was sent up to me, they satisfied it. The other person did not sign and satisfy.
Move
or
to dismiss.
Commissioner Grease moves to dismiss.
Second.
And seconded by Commissioner McMullen. Any discussion? Hearing none, all discussion? All in favor say aye. Aye. Opposed, no. Motion carried. Number 34.
2012012511. Complaint opened by Trek against respondent, affiliate broker, for failure to timely complete administrative measures. It appears that after being broker released, respondent did not affiliate with a new broker for almost 5 months. Respondent was sent an agreed citation, which included a civil penalty for this violation. Because respondent had not signed and returned said agreed citation, this matter was opened in legal. Soon after this matter was opened in legal, respondent executed the agreed citation and paid the civil penalty amount included therein. Therefore, the recommendation is to dismiss.
Move to dismiss.
Second.
Commissioner McMullen makes a motion to dismiss and seconded by Commissioner Grease. Any discussion? Hearing none, all in favor say aye.
Mr. Chairman,
Opposed, no. Commissioner Grease.
just as a point of information for me, do complainants and respondents get a letter from Trex stating the disposition of the case or the complaint?
When they come down to Connell, he sends, well, if there's a consent order, that obviously comes out of the legal department or some sort of other. But when it comes down to Connell House, our complaint coordinator, a letter goes out telling them what, just a short, what the disposition was.
Thank you.
There's three things I'd like to bring up right now. First one is Connell House. When I went over this morning to meet with Commissioner Giannini, Commissioner Bill, I saw Connell House. He said, Mary, he said, I'm not going to come over this morning. He said, I've got too much to do. So that's the reason Connell's not here. He's working on our behalf over there today instead of coming over here and listening to the legal report. Second thing I want to say is I hope that some law firm here in Nashville does not learn just how competent Julie Kropp is, because they'll be trying to hire her away from us. And thirdly, the way she can read as fast as she goes through this and reads these complaints for us, she would make an excellent auctioneer. So you may want to be an auctioneer in your next life. I'd be glad to sponsor her as an auctioneer. But anyway, that's now. the consent order law.
And I believe you all have that on your iPads. If you don't have any questions, we had one consent order last month, and the respondent did satisfy that, and so it's closed. If there's any other questions, you can ask them. It's probably pretty self-explanatory.
Anybody have any questions, Ms. Crop, on our consent order law? If not,
I just have two other quick things. I'm sorry, I
Okay,
don't want to
that's
mention.
okay.
First of all, I thought that you all might want an update regarding where the RFP stands currently, so I checked with Dan Birdwell. He advised me that the RFP draft that we submitted was approved by the Central Procurement Office, and we are waiting on the final approval from the comptroller. So at that point, I understand once that is done, this is my first round through with this, it'll then be issued. Is that correct, Ms. Maxwell?
Yes, that's. I thought it would be a couple of weeks, maybe.
Right. So that's just an update on RFP. One final thing, last meeting, Mr. Alexander had asked a question that he wanted me to look into, and that was with regard to a licensed broker representing and accepting a commission from an individual if that individual is buying or selling an option. I looked at the definition of broker under our statute, and I'd spoken with Mr. Pugh on this before, and I also spoke with Ms. Ryan about it as well. The definition of a broker includes any person who receives valuable consideration from another for soliciting, negotiating, or attempting to solicit or negotiate the listing, sale, purchase, exchange, lease, or option to buy, sell, rent, or exchange for any real estate or the improvements on the real estate. Therefore, it would, based on that statute, it would appear that a licensed broker would be permitted to represent someone on the negotiation or sale listing of an option, as it appears to fall within our definition there. And I hope that answers your question.
My question, it means I can do it. You screwed up a couple earlier. Yeah, I was wrong. Now, the second part, you don't answer.
Second one, yes, that's one I'd also discussed with Mr. Pugh and Ms. Ryan as well. Wanting to know about if an unlicensed individual who owns an option on a property, if that person can sell their option to someone else, not having a license. It is our opinion, based on these statutes, that if that person is negotiating for themselves, if they're buying and selling their own option, that's not something that falls within the realm of unlicensed activity as under the definition. And with 62-13-102, which is titled broker or affiliate broker identified by a single act, it says that any person who directly or indirectly for another, with the promise of receiving consideration from someone, does any act specified under broker, that makes them, they're deemed to be a broker or affiliate broker. If you are buying and selling your own option, you are not doing that for another, and so that is why we would think that would be the distinction there. I hope that explained that.
You're saying that a non-licensee can take an option on Steve's piece of property, he can negotiate it and sell it to Austin and draw a fee or a profit
For himself, as the owner of that option. That's because they're not doing it on behalf of another individual.
So that's legal too.
Yes. And I think that resolved the two things that you wanted me to ask. And that's all I have. I just wanted to address that while we were still in my section.
Speaking of that microphone,
I'm talking myself.
oh, Mr. Alexander's up here talking to himself now. You have anything else, Julie?
That's all I have. Thank you.
Since it's 20 after 11, you want to just wait and take up Mr. McDonald's report, the education report, immediately after we have lunch at 1 o'clock?
That's
I'm most confident
You do?
proceed.
Well, let's proceed and get you out of the way then. Next, we have the education report.
All right, on your iPads, under the education report for course information, you have 16 courses before you. Are there any questions? I found no courses that require discussion for this meeting.
So you are confident that all 16 of these courses fall within the realm of what we want our licensees to know?
Yes, sir. Pursuant to the rule and the statute.
I have a question on that last one.
Okay.
On the, let me see if I find it here. Investment. Tennessee Human Rights Commission. Dealing with lending practices. I didn't know how pertinent that was to the Real Estate Commission.
What number is that one, Commissioner? 815. Okay.
This course, titled Identifying Mortgage Abuses and Fair Lending Violations, as the description reads, those that attend this conference sponsored by the Tennessee Human Rights Commission, which is also a part of our Shrek manual in the back of it. This course will speak to fair housing, mortgage fraud. It also speaks to the relevant current topic of foreclosure and the fair housing and lending process as it's discussed through underwriting and fair housing in communities. So it applies to real estate. It's open to the public. They requested CE, since it's an all-day conference.
It looked like to me it was a course that somebody was wanting to transition from one profession to the real estate profession and wanting to get 8 hours credit. So I really don't see how it would affect the real estate agent. We can't do anything about the mortgage. Well, we've tried to do it before, and I just wondered if you really think that's legitimate for our profession.
Based on the two folks that they've got coming, speaking, experts in the field, it discussed and talked on points that would be relevant to a licensee to assist them with their business and also helping protect the public.
Okay. My definition of an expert is somebody 50 miles away from home with a briefcase.
Commissioner Grease.
This is a one-time course, is that right, Steve?
Yes, it's a conference.
2 days, or you're going to get 8 hours in one day? Let's go. Teach your core part. That's okay.
Looking through the course, it does not specify whether it's 1 day or 2 days, but it touches on enough points that it is an all-day, high-level conference. And I'd be more than happy to pass this around if you'd like to review it.
I'm ready to go.
For you, thanks.
You recommend it, I'm for it.
I make a motion, we accept the courses as submitted.
A1 through A16, all the courses submitted. His motion has been made by Commissioner DeSharle to approve. Do I hear a second?
Second.
Second by Commissioner Grease. Any further comments or discussion? Hearing none, all in favor say aye. Aye. Opposed, no. What? No, I'm trying to keep tabs up here.
Moving on.
You didn't hear me?
Shut up. You
You all
didn't.
have the same inflection in your voice.
Sometimes I vote, sometimes I don't.
No, she thought that you had seconded the motion, but it was John.
We're working on a ventriloquist.
We'll have to separate them.
I'm not used
No, that's not going to happen.
Okay, Steve.
Yes, sir, Chairman. The instructor approvals, Karen Zarnicki of Williamson County Association of Realtors approved provider 1135, who is also in the presence of the commission today.
She's here. Hello.
Request the approval of Susan Barnett to teach their accredited buyer representative course, which is a TREC approved course 6610. Susan Barnett is an approved provider. Her provider number is 1397, and the instructor, she's also an instructor with TREC. She holds a Tennessee broker's license 261670. It would appear Ms. Barnett, based on her experience in credentialing, is experienced to teach this course.
You recommend that we approve her?
I do.
You have heard the recommendation of our education director.
Second.
What? Nobody's made a motion yet. We made a recommendation.
I'll move for approval.
Commissioner Grease makes a motion with, and we have a second by Commissioner DeSharle that we approve Susan Barnett as an accredited buyer representative teacher. Any discussion? Yes, discussion, Commissioner
I'd
Grease.
like to ask a question after the vote. It's not pertinent to this necessarily. This
Okay.
next question.
Okay. Question on the motion has been called. All in favor say aye.
Aye.
Opposed, no. Motion carries. Commissioner Grease.
All right. So, Steve, if it comes to your attention, whether it's correct or not, that an instructor might be teaching things that aren't in compliance with the policies of the Real Estate Commission, do you take it upon yourself to call that instructor and try to straighten them out? Or what? How do you handle something like that?
They are contacted. I would like to see what is given out in class. I'd also like, as a complaint reads, not to the extent of a licensee complaint, but I'd like to get a statement from the attendee, the licensee that is sitting in the class, to get both sides of the story, and then I bring it before you based on the facts for your review. But yes, with over 600 instructors, 1,427 courses, and nearly 200 providers, it is always good to know or be told what's going on in the field.
Instead of going through all that process, do you or could you just call the instructor and say, "This is what I heard. What do you have to say about it?"
Yes, and if there appears to be a violation of what is set forth in the rule and the law, then I would want you, as a commission body, to review it.
My short-term goal would be just to correct the instructors who may just have it wrong. Say, that's not, if you're saying that, that's not right. I mean, I don't necessarily need for you to bring it before us if we can just correct it. If that's the issue, I don't know, but I'm just curious how that was handled.
Is there a current issue that we need to...
I got a call from Chattanooga about a course, and what an instructor was saying, related to a policy we've recently adopted here. Maybe you're aware of that.
I am. Ms. Maxwell is aware as well.
Well, is that something you guys can handle internally?
We did. We took care of the situation.
That's all. That's perfect. That's what I wanted to know.
And I believe there was some misunderstanding between the student and the instructor in that.
There are always two sides, at least. Okay, thanks.
Yes, sir.
This last month, TAR's online report suggested that it was illegal again to do dual agency with that, and would you clear that up with them, that as far as the Tennessee Real Estate Commission, as long as everything is disclosed, it's legal? Would you please disclose that to them?
Yes, sir. Mr. Sexton is also an audience, and I'm pretty sure he was aware of that. In our share line, based on the last commission request, that was put in there for the instructors that dual agency is, which is also loaded onto our website. You can go on and look now. I don't know if your iPad is linked to the internet, but you can look and see our current share line states to the instructors and providers that dual agency is recognized in the state of Tennessee.
But the charge I just addressed it and said you shouldn't do it.
I will send a letter to Puck Scobrow and Steve Harding and Chris Sexton.
Let him know that this body makes the rules and not his body.
Mr. Chair.
Now, don't shoot Chris, he's just the messenger.
Or me.
Yeah,
I agree, I agree.
Yes, Commissioner
You've got to work.
Northern.
The staff conducted seminars in Memphis a couple of weeks ago, and I attended one afternoon session, and I'd just like to report that it was a very well-attended seminar and very well conducted. And I have to say, I saw a new invigorated Stewart in that process. He seemed to have kept up a little bit, but it was a good session. Appreciate you all coming out.
I'm looking forward to them coming to Knoxville. Sure be there. On my calendar. Anything else you want to bring up, Steve? That's your report. We are breaking for lunch. Be back here at 1 o'clock. It's right now 11:30. Megan's high.
Okay, it's on. You ready? It's on.
I call this meeting back into session.
Go ahead.
Run the meeting.
Okay, for all that racket over there. I'd like to, at this time, turn the meeting over to Ms. Eve Maxwell, our Executive Director, for her report.
The first portion of the report is the complaint report.
Ms. Maxwell, would
yes.
there be any way that you could skip down to the electronic storage of documents?
Sure. Before we do that, can I just make a quick announcement?
Yes, you can.
Somebody brought me this card. It's a credit card with the name David Allison on it. Is David Allison in here?
That's my other name.
Let's go shopping, Julie.
No David Allison? Okay. I'll check again later on.
He may be out there looking for his credit card.
He might be.
Well, some kind soul in here gave it to me to make the announcement, so. Okay, I'm sorry.
Did you want to move to electronic storage of records?
I was wanting to ask Cindy Rice Grissom, had you expressed an interest in talking and sharing some information when we talk about the electronic storage of documents? Okay. Yeah, you go ahead and start talking about whatever you're going to be talking about, and then Cindy Rice Grissom, Chair's going to let her speak as the provider of our E&O insurance.
Okay. Hopefully, the commissioners have all had an opportunity to read the memorandum I wrote on the electronic storage of records that we emailed to everyone. I guess really probably the chairman hasn't had an opportunity to read it, but it outlines the concerns and the approaches to the electronic storage of records. This came up because the commissioners had expressed an interest in setting some sort of a policy regarding the electronic storage of records, because a number of our licensees are moving towards that to save money on storage and to facilitate the process of getting records in from the affiliated licensees in the field into the office and then being able to check over those. So so I did some research on the electronic storage of records, and this sort of compiles all that together. The highlights of it, I don't really know how you all want to approach it. I don't know if you want to get into a discussion of the memorandum itself or just the highlights of the electronic storage of records, exactly, how you all would like to approach it. I think that there are several items that are noteworthy and important for the commission to consider if they're going to set forth some policy in regard to that. The records under our statute have to be available at reasonable hours to be inspected by the TREC auditors. They have to be in a format that the TREC auditors can review and easily find their way through and make copies of if that's required, or we could request copies of those. So as one considers the electronic storage of records, one has to be sure that those documents can be easily retrievable and in a format that's easily readable. And that sounds like a fairly simple thing to do, but when you go, and we're setting up our electronic storage right now in the office, so I've sort of been through this process over the last couple of weeks. You have to figure out a way to index those documents so that they're usable to you. You can't just say, okay, I think I'll just throw all these documents in here together, because then you can't find anything. You think in the front end, oh, that'd be really easy. I can just find the stuff when I'm looking for it. But you really can't, so you end up wasting a lot of time. So any storage of documents requires a lot of front end thought. You also have to determine whether or not your firm can afford that and whether it fits the current budget that you've got, the future budgeting. You've got to make sure that whatever you choose as your format, that it's going to keep those documents in a readable form, and that you're going to update it as the new versions come out, because otherwise you might find yourself with an older version that's no longer accessible or no longer in a readable form. And it's a relatively expensive proposition. It's cheaper. I mean, it's certainly cheaper than having boxes stored in your office probably, but it is an expensive commitment of time. It's time on the front end, time making sure that it corresponds to the things that you need, and that you can look under, say, a salesperson and find out, what houses they've sold or maybe what houses they have for sale, and so that you can look at your inventory of what your firm has. And you've got to be able to go through those files as if you were going through a paper file, sort of in your mind as if you were going through there. You have to make sure that if there's a complaint filed or a lawsuit filed, that you've got those documents in a format that can be printed off. If you've got a complaint, then you need to be able to turn those documents into us with your response. If you have a lawsuit filed, you'll need to be able to access those. Those are all things that individuals need to consider. Particularly, I think the price is something that a licensee needs to consider when they go through that. You have to retain the documents for 3 years, and if you have, the complaints can be filed within 2 years of when you first become aware of a problem. So that means it could be 5 years or 7 years even before a complaint might be filed, because someone might not become aware of a situation before that. So, that adds some additional consideration. It may not just be the 3 years that the statute itself requires. It may end up being a longer period of time that one needs to retain those documents. That's kind of the highlights. I don't know, as I say, that I have a whole lot of information in here, but I don't know what else you all would like to discuss, or I can answer questions.
Given the change in the industry, from the standpoint of technology, we probably need to at least advise licensees what's expected. And basically, it's the same thing as expected of hard copies. We want to have access. They got to be available. We need to know how to get them, or they need to know how to get them when we request them. I don't think our auditors go in and the files and pull things. They just tell us what they want and pull them. So I would assume that same thing would apply here. So some kind of notation on the website and in the newsletter or the news report that would make them aware for those who are either contemplating or already have in place electronic storage.
Well, one thing I think is going to be an ongoing problem that we're going to have to address in our rules is the format which they store them, because our auditors are going to have the software capable of opening their files.
So it's like the files in your office. They don't go in your file cabinet and ask for any cool stuff. They just tell you what they want.
But if they tell you they need this file and the only way they got it is electronically, then what are our auditors going departments do? So you gotta go print that file off, or are they gonna take that file as they are given, which is in an electronic format? If it's in an electronic format, then it's gonna have to be determined what software our auditors are gonna have to open it. If it's gonna be a PDF, if it's gonna be a Microsoft Office, or what format it will be in.
What?
I'm not saying it's not a bad thing. It's not a good thing to do, but we're not retrieving it. How they get it to us is not our issue.
Well, but we are retrieving it. If Johnny goes in and says to you, I need 5 files, and you're all electronic, then are you going to print everything that's in those 5 files? Or how are you going to give it to them?
Well, I'll just use our company as an example. We were audited a few months ago, and one particular file, we normally will print off stuff and maintain a hard copy as well, because I asked for a copy and I don't like trying to retrieve it. So it was in hard copy. He reviewed the hard copy, but one page was missing, and it was the signature page. It wasn't in the file. My son pulled it up. It was there. It had been signed. It was a short sale, so it was one of those situations where that page didn't print. You couldn't print it for whatever reason. So he viewed it on the computer, and he was happy with that because he saw that it was a part of the file.
So he used your software to view
No, he
it.
didn't. He viewed what was on the screen.
Yeah.
But he didn't have to pull it up. It was done for him.
But it would be a rare event for an auditor to take files away from the office he's auditing, correct? So if he just looked at the computer screen, I think that would be fine, as long as he knows as long as the company has what he's looking for. Back to your point about, here's what we want.
And you have to we have to be assured, TREC has to be assured that the documents that they're seeing are, that they're accurate, they're authentic, that they are accessible, they represent everything that's there, and that they were, there's security measures to keep, someone from hacking into the system or breaking into the documents and getting those documents or altering what's in there. I mean, so the TREC has to be as assured, not that they couldn't do that to a paper file, but they have to be assured that those things have occurred, and that everything that's in the file has been scanned in, because some of these brokers will destroy the file. They'll shred the file because their intent is to save money and not have the paper backup. And if that, and ultimately the state will be paperless, or somewhat paperless, and so everything will be coming in an electronic format. And the state has set forth a model electronic document records act that says basically if you can authenticate it and if it's been proven to be in a fashion that is dependable and reliable and maintained, then that will be considered as the original, and electronic signatures as well will be considered as originals. Because that probably will become more and more of an issue, and something that I would assume the licensees run into. In several states, including in the memo, have some policies and procedures and ways to go about that.
It seems to me, Mr. Chairman, that staff needs to come up. Ms. Maxwell has done a good job putting this in a letter form, but let she and legal come up with the requirements that this commission will either do by policy or by rules making to make it binding. And my suggestion is that you all make up this outline, and then you give it to each one of us to read, to study, to make our own recommendations and add or take away from it.
Is that a motion?
That's a motion.
That's a second.
We got a motion and a second that staff and legal get their heads together and come up with a policy that we either adopt by rule or policy, and addressing the electronic storage of records. Any discussion on this motion in the second?
Just quick question. Eve, did you, these different states that you provided, did any particular state stand out to you personally as a good model to follow?
I think I think the Oregon's is good. Kansas was one of the early states to do it. I don't know that we would want to get into as much detail as, say, Arizona has. I mean, theirs is pretty specific, and South Dakota's is got a few specific things. But, I think that you don't want something that just like has just step by step. I mean, I think you want more of a general policy that allows for a little bit of flexibility, don't you, Julie?
I think we'll put our best together.
Yeah.
But that would be my inclination.
So do you want us to draft up something, then we'll send it to each of you, and then you all will comment back to us so that you have time to do that before the next meeting? I mean, comment back. Okay.
Now, Mr. Chairman, okay. Cindy, you have anything you want to add to this conversation, if you could, before we vote? That might.
Right there, that black chair, because that microphone's on.
All right. I'm here to speak.
Stay
Okay. Can you hear me now?
Yeah, for the record.
This is Cindy Rice Grissom with Rice Insurance Services Company, as the current provider of the E&O Group Insurance Program for Tennessee Real Estate Commission on behalf of its licensees. When this issue was raised to me, there was a question about how would this impact insurance coverage. I have to tell you, if there is an E&O claim, a lawsuit, anything against a licensee, it is so important to have the documentation from the file. The documents can make or break a case. Even if you have full testimony that there was a full disclosure given, if you don't have the document to show that everybody received and signed off on the document, it's very difficult to address a case. In fact, we have an ongoing claim right now where there was a disclosure statement. The broker says, I sent the disclosure statement to the purchaser via email. Well, guess what? They don't have that email file anymore. They can't retrieve it from their system. So I think it's very wise for the Commission to address this from a regulatory view to say, okay, these are the requirements. If you're going to go paperless, if you're going to have computer files, there are certain things that you need to do. As long as they have either a hard copy or a computer file with a secure backup, then from a risk management standpoint, you should be able to successfully defend the case and see what actually happened if you're looking at it from a regulatory board. It's not really a coverage issue because there's nothing in the policy that says you have to have files kept in a certain way for there to be insurance coverage. But if people aren't documenting their files properly, and that means that they can retrieve that file, then it's going to be really hard to prove the case, and there's a strong likelihood that if you can't produce the documents, there's going to be a large, there's going to be more liability, larger payouts, and larger payouts on the claims impacts everybody in the group program, because if you have larger payouts, then obviously the insurance company has to charge more premium because there's more risk involved in that particular state. But I think it's wise that the Commission is taking a view on this, and if they have specific rules to follow in setting up, if you're going to go electronic, these are the things you need to consider, and I think it's going to be a tough project from an education standpoint to really try to make sure that everybody understands what going paperless really means and how to do your due diligence before going in that direction to make sure that if you have to have proof of those documents, you have them. Because if there's if your system crashes and you no longer have those documents, that's not an excuse.
I just wanted that input before we voted on it. I would think that, Ms. Maxwell, that you certainly would want the guidelines to be parallel with what the paper guidelines are, and maybe some other things added to it. One thing that pops in my mind is everybody's going to say, well, I've lost it. We just went away. It crashed. My system crashed. But it needs to be backed up where you'll have that, because every time an auditor goes out and he gets to looking for something, or we've got a complaint, there will be some of those in the market will say, we don't have it, even though we might have it. If it's not documented, if you don't have it, all of them, you better not have any of it, so to speak, so there's no record. But that's just some things that I had in my mind, and I'm the one that asked Ms. Maxwell to come up with this, because I think it's here, and it's not going to go away, and I'm sure that we're going to get a lot of conversation when the word gets out that we're fixing to do this with those providers that's already got something in line that's not going to suit them, so you can get ready for a lot of conversation from a few folks. If you remember, we audited the firm a few months ago at my request, and we sent all 3 auditors there, and we audited his paper trail and his paperless trail, so to speak, or his computer situation, simply to get a feel of what and how they were doing it, and if they were in correlation, the two types were together, and I think it turned out very successful, did it not, Ms. Maxwell?
It did, but that particular broker, he put a whole lot of front-end time into researching the system, and has made a commitment to do it, and all the affiliated licensees have, made a commitment to do it, and he's got the staff to do it. But it was it's an expense.
We gained knowledge there.
Right.
It's like the little, it's sort of like the little kid in the 4th grade that told his teacher the goat ate my homework, so you gotta have a backup. Looks like
Is that Wilma or Crybaby?
Crybaby. Okay.
Your statement, it would really be well to impress upon the brokers that it's their responsibility to maintain those files, because oftentimes the affiliates may agree to do it, but they don't. So the broker needs to make certain that that's the way they're going to do it, that they make sure that it's done. Otherwise, it's their name on the line.
And you're going to have some of them, just like this broker auditor, they say, well, the agents keep up with it, we don't keep up with it, but it's the principal broker's ultimate responsibility.
Miss,
Can you imagine they're going to vote?
Miss Grisham, I take it from the gist of what you were saying, it'd be nice if you had the paper trail, if you still had the paper files. If you wind up having to go to court, you need those documents, to be able to provide those documents. It might be in your best interest to have them. Did you not say that?
That is true. Sometimes we get sent files currently electronically, and like a PDF file, and then we'll make copies of that and keep the PDF file in with our documentation for the claim. But we always print everything off, because that's just the way we do business. We have a lot of paper in our office. I know a lot of people are going paperless, but I like to have both. But from y'all's standpoint, I think the important thing again is that that they be able to retrieve it, and they be able to provide it to somebody else if they need to review it, whether it be the auditor or the courthouse. If we've got to defend you, we need a copy of it in our file, and the attorney that's defending the licensee needs to have a copy in their file, so they can say, here's a copy of the document, whether it's electronic or paper. It could be either, but it needs to be in a format that could be shared with the other parties to the lawsuit.
Any more discussion on the motion that Commissioner Alexander made? Direct staff, Eve Maxwell, and the legal to come up with us some kind of policy. Hearing no more discussion, all in favor say aye. Aye. Opposed, no. Motion carries. Thank you, Miss Cindy Rice Grisham. Continuing on, Miss Maxwell.
Going back to the agenda, the complaint report is the first item on the agenda, and on your iPads, I suppose. The first page of the sheet 1 of the complaint report. Sheet 1 of the complaint report shows that we currently have 103 outstanding complaints. Right now, we have no E&O complaints. But do remember that E&O comes due on 12/31 again of this year for most of our licensees. As I say, we have 103 complaints, 58 are consumer complaints, 12 are fellow practitioner complaints, and 33 have been opened by staff. So we have, since this is the beginning of our fiscal year, July the 1st was, and this covers July the 1st to July the 31st, we have 33 complaints for the year. Last year, for the entire year, we had 386 complaints, and we had 220 that were closed last fiscal year, and we've had 31 closed in the month of July. The civil penalty money that we have gotten in July was $22,090, and the total amount of civil penalties that we had for all of fiscal year 2011 to 2012 was $273,662. That was for the fiscal year that we just ended.
How's that compared to last year?
Well, last year, you can see last July, the first month of the fiscal year last year, July 1st to July 31st, we had gotten $18,840 in civil penalties compared to the $22,090 that we've gotten this July.
You don't have the figures for 2010, 2011, do you?
For the complaints?
Yeah, for the total amount of money. The total amount of money, that's what I think Commissioner Alexander asked.
Oh, I'll probably do in some of the budget information. I can get it. I don't have it like right at my fingertips, but I can get that.
Doesn't matter.
Yeah, it doesn't matter.
Are there any questions about that? If not, the licensing statistics of the next order of business.
I have a question.
Okay.
How do you arrive at the people that you're going to put on the board?
On the DAR report, the disciplinary action report?
Yeah.
Those are individuals that have paid the civil penalty or a civil penalty.
But there's more than just this amount of number for that period of time, is it not? I'm looking at what there's about 4 that you're printing every month.
You mean for the same people?
No. In other words, there's a $250, $250, $250, $550, and $1,000.
Right, so like the 250, those would be, the 250s are the citations. I mean, that would be a form of citation that would have gone out. Like the one, the first 2 up there where you can see are failure to timely complete administrative measures. So that the ones that you see there, 250, primarily arose out of audits that were done by the auditors, and there's a schedule of fines that the commission approved 5 or 6 years ago that set forth the schedule for citations. And then those citations that aren't paid, or a couple of which you heard this morning that Julie presented as complaints. Would you like us to distinguish the citations from the
Well, I
complaints?
just thought that those that you can go online and pick up every one that's ever fine that's paid. My thinking, reasoning was that the people that pick up the commission report, if they saw the larger, more complex files and what it costs, which would stick in your mind to abide by the broker.
Right. These are the people that just paid this month. These are the people that paid from July the 1st to July the 31st this month. The ones, I mean, so that, say last month, the older ones, the historical ones are linked on our website so that you can not get to there's a great big one that's on the Commerce and Insurance site that includes all the reg boards. And then there's a link from our site that will take you to our historical disciplinary action reports. But these are just the fines that were collected in the last 30 days. So sometimes it has, yeah, so it's just a function of that.
So the guy that settled yesterday, when will he show up in this
He'll show up
report?
on the August.
If he pays the money.
Correct, if he pays the money. Well, he paid the money by cashier's check. So he'll show up on August 1st to August 30.
It'll be in this report,
Right.
No, he won't be in this one because this one just is up to you.
No, in August.
Right, he'll be in the August report that you'll see in September. So he'll show up then, because this is done every 30 days, and like a copy of ours goes up to Commerce and Insurance for them to put on the big report as well.
Part of the penalty was, I don't know if you want to call it that, but part of the penalty was coming here for 2 days. Does that ever show up as part of the penalty?
We don't put that on here. If you would like us to start putting that on here, we can do that. That's no problem. I mean, we can do that. That would certainly, for the most part, distinguish the citations. I mean, right off, just by looking at it. It would not be on the big one because they only want monetary fines on the big one, the one that goes to Commerce and Insurance. But we could put it on this one.
John raises another question in my mind. Those folks that paid this $250 civil penalty for violation of advertising, is that a consent order does that, or is that voluntarily?
Well, normally, the advertising is a citation. It sort of depends on the situation, but the advertising, by and large, comes in anonymously in plain white envelopes with just a picture of whatever the violation is.
Well, my question is, are these people that paid the $250, are they required to come to the 2-day commission?
Not if it was just a citation. No, at this time they're not required to come to the commission meeting. If it's just a citation, if it's heard by, if it ends up in front of the commission, then yes, they are. So like the ones that, that if Julie would present it and it would be a consent order, it would take the form of a consent order, then they would be required to come to the commission meetings.
All right. Operating an unlicensed property management company, the civil penalty was $1,000, but they didn't have to come to the commission meeting, right?
That was a decision made. I mean, this was a consent order that the commission decided upon.
My point is that there's a group of people here that have to come. Well, I'm concerned everybody comes.
The citations as well.
If the rest of the people have to come, everybody else has to come. Okay. That's my opinion.
It sounds like. Well, you can just call for it.
That's just my thought. I don't hear any other conversations, so let's move on with that.
Well, I'm just, I hate for it to keep going on record that I agree with you, but, I mean, this is just going to be a habit. But obviously those people didn't know any better, so they did something they shouldn't have done.
Well,
so I kind of agree that they need to come to some education.
I just think what's fair for one is fair for the other. It's not, you're not. These people should have to come too.
Right, the people who get citations, agreed citations, that should be incorporated into the agreed citation.
Would you like to put that in form of motion?
Yes, I would.
Mr. Alexander?
And I'll second it.
Everybody ought to be treated alike.
We have a motion by Commissioner Alexander and seconded by Commissioner Descara that included with these agreed citations will be a requirement to attend a Tennessee Real Estate Commission meeting. Normally we do it within 6 months. You will include that in your, make it part of your motion?
Yes, I would.
Okay. We have a motion and a second to that effect. What discussion do we have? You ready to vote? Yes.
I got a question. Are we going to create a situation where not going to have room for all these people to come in here?
I doubt that. Still got 12, 15 seats or 30 out there today.
Right.
We'll just bring some more chairs.
The thing about it, they get 8 hours of continuing education every time they attend one of these commission meetings, so it's not all.
No, not
all.
every time. You can only do it once every 2 years.
Well, yeah, once every 2 years. I mean, surely to goodness they won't be coming more than once every 2 years.
Well,
Are you ready to vote?
I have a question.
Yes.
So, who do you want to come, the broker, or do you want the affiliate?
Who got the
Whoever
line?
got the citation,
Well,
the broker or the affiliate.
if I've got a license that's out of date on my wall, and the auditor comes in and says that license is out of date, who's going to have to come here for 2 days?
Everybody's responsible for their own individual license.
Well, not our general philosophy is the broker is responsible. Right, we got 12 seats left.
We will fill up the room then.
Can I say something just real quick?
Yeah, we're still under the discussion phase of this.
And we can certainly look into this before next month, and you can go ahead and do the vote now. When there's an agreed citation, it's not opened as a file in legal. It's not on our complaint report. Typically, when I have a consent order that requires payment of a civil penalty and track attendance within 6 months, I track it, I watch them. We've got the automatic suspension language in there if they don't comply, and that's how we deal with that outstanding requirement. Agreed citations are slightly different because if you put that requirement in there, I'm going to need to look into a little further what we do for the people that don't comply because they're kind of in a different situation. And I just need to look into a little further what can be done there because inevitably you'll have people sign it and agree to come that may not come. And we need to be expecting what to do with that. And I may just need a little time to look into that.
You're asking us to perhaps wait till next month to do this?
If you could give me a chance to look into that, because I hate to set a requirement that it's going to be difficult for us to keep track of and then do anything about it.
Commissioner Deshar, would you remove your second?
I will.
If he withdraws your motion, just withdraw it and get off the floor. We'll deal with it.
I'll make
Table it. We'll deal with
I'll
it.
make a substitute motion. We defer for 30 days.
Second. We're going to defer for 30 days. All in favor say aye.
Aye.
Those no, defer.
I'll look into it.
Okay. Now,
Of course, we showed up in a hurry, too.
Are we ready to go on?
continue on.
Okay. The next order of business is the number of licensees, the licensing statistics. And as you can see that our number of licensees, the grand total, is down this month. Our active licensees are actually up. We have 23,684 active individuals, and that's up 60 from last month. We have 904 inactive, which is down 30 from last month. Our retired licensees are down 175 individuals. So we have 9,858 retired individual licensees.
Ms. Maxwell, right
Yes.
there. Is the reason that 175 is down from last month, is that because they just let their license go away while it was in retirement? They didn't pay the renewal fee?
Yeah, I think that, I mean, it's hard to say because that's a figure that had gone kind of crept up like 30 here and there, and we hadn't seen a decrease in that. I think that some of those people have paid their fee for, their renewal fee for a number of years and now are looking at the, just the economics, and maybe they thought the market was going to come back in 2 years and then 4 years, and now they just aren't paying that money. Our renewal percentage, percentage of renewals versus non-renewals seems to stay about the same. I mean, it hovers between, say, 12 and 15%. So, it hasn't, like our non-renewals haven't gone up dramatically, but I think that it's hitting the retired individuals, particularly hard. I think they really are looking at the economics of it, because these people already have their education. The inactive individuals have to get education, so you can see that might be a deterrent to some of those individuals to, say, I'm just not going to get my education, I'm just going to let my license go. The retired people, on the other hand, they have education, and they could just pay and stay there for as long as they wish. And I don't know. And the broker release, that number has gone down from like 2 or 3 years ago, it was 2,300 people we had in broker release, and now we have 427. And those are people that, you know, that they wouldn't have renewed, like in broker release, you're not going to renew anyway. So it's kind of hard to see how that number just so dramatically dropped. But it has dramatically dropped from like 3 years ago. It's only down 38 from last month. But fewer people are remaining in broker release. A lot of them are just letting their license expire. And I think a lot of those people came in during the height of the market. You know, like they came in just as it was going up. And then, you know, it fell off and they decided they needed to do other things because our numbers went up so much there. And a lot of these people who are letting their licenses expire, when you look for whatever, you know, look in their file for whatever reasons, they've only been licensed 2 years or 4 years. You know, they haven't been licensed a long, long time. A number of them who are just letting their licenses expire.
I know in
this long, it better hold on a little longer.
Yeah, in January of 07, we licensed 830 new affiliate brokers in January of 07. January of 11, 4 years later, we licensed 72. I do remember that statistic.
So that's, yeah, I mean, it's gone down dramatically, the number. And the number of people testing has gone down. I mean, I thought it was going to start back up, but it hasn't. I mean, it hasn't started back up. I mean, every time you think it's going to start back up, we have that next month where it falls back down. So I don't. You all know. You all are out there. You know more than I do about what's really happening on a day-to-day basis. But you can see from like from 08 to 12, from 7/30 of 2008 to 7/31 of 2012, we are down 9,900 licensees, individual licensees. So that's a big drop in, of almost 10,000 in that 4-year time frame. And I don't know what the normal will be, like when we reach that normal point. The firms had not dropped off as much, but this month we're down 50 firms. We have 4,069 firms. And we had 11 that were retired, and we have 11 that we are down from last month in the retired firms. So our grand total of firms is 4,383, which is down 61 from last month. And our grand total of firms and people is 39,256, which is down 244 from last month. And as I say, that number, I thought that number would have leveled off more by now. As you flip through or if you turn to the next page, you'll see the approval by type of the licensees, and you can see we had 209 licensees that were approved for July, and of those, 111 were affiliate brokers, and 23 were brokers. And from reading the other real estate commission's newsletters, it looks like there's a broker fall off pretty much in every state across the board, that there's a fall off in the number of brokers, people that are actually testing for broker if they have that status. And some states are seeing a more significant increase in affiliate brokers. And I know when we give our seminars, there are not many brokers there, and not often no one raises their hand when we say who wants to be a broker. I mean, there's not a soul that raises their hand sometimes. Just interesting. And I don't know if there are any questions about that. I mean, we have lots of statistics. If you look at the very last page of the additional statistics, you can see that all of our licenses issued as of 7/31/2012. So this takes in the affiliate broker, and timeshare, which are the ones that are always listed on the front, and then the real estate firms. And then you can see that we have 50 timeshare active registrations and 132 exempt timeshare registrations. And then we have 144 vacation lodgings, 41 acquisition agent registrations, 2,331 acquisition representative registrations, 123 acquisition agent licenses, and 96 designated agent licenses. So our total of licensees, if you look at all of the disciplines and professional status codes, is 42,372. So we sometimes we sort of forget to mention the other, the other licensees that we do have. Are there any questions about any of those? The next order of business is the meeting schedule. And at last month's, the meeting schedule for 2013. At last month's meeting, the commission made a decision to lock in the first 3 months of the year, the dates that had been chosen for those, and then left the other 9 months open. And we were going to investigate the state parks and see if those were options. Kelly called the state parks and got on their website and emailed back and forth with an individual there. And I don't know if you want to talk about what your conversation was. You want me to say it? Okay. There are a number of state parks, and they have, they all look like they've got, great facilities. The problem is that they do not have recording equipment, and if you're going to get it, you have to pay for that. They don't have, most of them don't have food service, and if they do, it's like maybe a buffet here or there. A lot of them have cabins and no inns, like inns that you can stay in, but they have cabins. And they, by and large, they don't appear to be set up for the type of meetings that we have, since we have to record, we have to video, we have to have, a true record of what occurred here today. And that's, so I don't think those, it does not look as if those are going to work out to be cheaper alternatives for us, as opposed to going to a smaller town or going to another town where we usually go. I mean, unfortunately.
Fall Creek Falls were not requirements.
Well, is there not somewhere like at Cookville?
He said none of them.
No, no, I'm talking about like one of the hotels or something there, that if we wanted to go to that area, we could go.
Well, I assume Cookville has a county commission.
Yeah.
Right.
So, I mean, why could we not still?
I just looked at the parks. I mean, he just said none of the parks are equipped.
But that doesn't mean,
But I mean, county could, if you're going to like a county seat, then they should have some kind of commission. And usually when you have county commissions, it has to be recorded as well. So that's why we so often meet at commission offices or courtrooms, because they actually have the recording equipment.
the parks have great, they have great facilities. It's just that they don't, have the facilities that we need to carry on our meetings. But they do have great facilities.
So you could decide to do it in Cookville. I mean, if we need to get this on the books today, and if I hit a brick wall or something, I could come back and tell you guys that. But I think any town that has any size would probably have some kind of commission change or something. I don't think we could go to Martin or something.
Well, actually, you probably could go to Martin.
Really?
Probably go to college there.
But Memphis wouldn't let us go for free there. Memphis, when you tried to get Memphis, University of Memphis, they wouldn't let us go to for free.
They would, they like to make money. But,
Yeah.
UT Martin, I don't.
Yeah, the schools do charge for rooms.
But maybe we could find, if you all decide on a city, then we can look into, we can try to find a free place with free equipment.
In Memphis, it just depends on what. It just depends on what campus you're on. The University of Memphis has an extension in Millington. And I'm part of another quasi-governmental group, but we meet there all the time for free.
And they have
They've got
recording.
great facilities.
Yeah.
And where is that, Isaac?
I drove through there.
Well, as I say, we can, whatever you all decide, we can look into it. We could just
I wish
into
you'd
the
look
parks.
at us going to Cookville. We've been to Chattanooga, we've been to Kingsport, Pigeon Forge, Knoxville, Jackson, Gallatin, Memphis.
Why not Cookville and Oak Ridge, maybe?
I know. Let's just go to Cook.
Something close to home.
Too close to home.
But if you want to do the 40-year breakfast in Knoxville, then
And we won't do that in Knoxville.
that would sort of, that would sort of be.
Oh, we can do that in Berry.
Yeah, I'm working on that. But let's just start picking this calendar apart here. I'd say October 10th and 11th, we do it in Knoxville and have the breakfast at the same time. Probably it's a football game then, fall colors, be beautiful.
Okay.
Let's start picking this thing apart. We got 9 months we got to handle here.
Okay, 10th and 11th. This year we're going in October, we're going to Chattanooga. Next year we go to Knoxville and have our 40-year award.
Then we'll have the meeting on the first day and the hearing on the second day, correct? I mean, that'll be our,
Yeah.
okay.
Well, why don't we try to go to Cookville in April?
Well, we got, what about May? This Thursday, and Friday.
Yeah, this is Thursday and Friday. We've already got scheduled for Thursday and Friday in May. When's the baby coming?
Oh, I'm good with it. Please don't do anything in March.
We're just misbehaving.
They can't hear me.
I think it's May month.
Are we going to go to Weston?
I was gonna say, where are we going in West Tennessee next year?
You know, normally we go in May, but we don't have to.
We went in January and July this year.
I'd like to see us go to Paris. Paris. Tennessee.
They got a state park.
I talked to them about Paris Landing. They don't have the recording equipment either. That was the first place I thought of.
You'd have to go there again to City Hall or.
I'm not sure what their recording facilities are.
I was going to say, what do they have in Paris besides
Catfish.
antiques?
Catfish.
Yeah. And a miniature rifle.
That's kind of like Martin.
We're not going for entertainment. We're
No.
going to,
I don't mean that. I meant like office. Hey, that's my neck of the woods. You're not. I'll go there. That's
You
easy.
sure they don't have, talk to the park.
His name is Ronnie Douglas. He's a salesperson. He does all across the state.
But they have at Paris, they have a building out from where the restaurant and the motel is that big center there. They've got I bet you that
Is it part of the park?
part of the park.
We're on 79 or something.
I think Pittsburgh has facilities as well.
It's the recording.
It's the recording equipment that they don't,
We might could get some recording equipment, the cost of that underwritten.
it usually costs like $1,200 or $1,500 to get it. But like Pierce Landing, they have a number of meeting rooms. I mean, they have a conference center. It's $1,000 to rent, but that's really big. But they have a number of meeting rooms, but they don't have recording equipment.
Yeah, no, I was on the phone with him for 45 minutes. Went at it at every angle I could possibly think of.
Well, did you ask him
They
about?
barely have microphones.
Yeah, they
have
have
two
some of
microphones.
them, We have, they have a book. They have a really fancy.
Did you
pronounced.
find out about like City Hall or anything there?
In Paris.
Do you want us
Told me to
to?
do parks.
Parks.
Do you want us to? Well, do you want us to look into Paris for?
Oh, Paris.
Rent. See what the city.
You're talking about
I'll work on it. I'll work it.
I'm pretty sure they got something.
It's the problem is the recording. I mean, that really is the problem. Is the mics? They don't have amp out mics. You know, they just have. Remember that time in Memphis when we met and we didn't have any amplification in the mics. They have like lapel. They don't have the capability to do what we need to do. They got like great meeting rooms. I mean, like Pickwick's got 5 meeting rooms. They've got good meeting rooms. But the problem is that, or they don't have and/or none of them have all their equipment, but they also don't have, all the places don't have inns, like they don't have places to stay there. Yeah, I know, I just meant some of them don't, some of them just have cabins. I mean, we could look into renting equipment.
I think in those small towns, you're not even going to find it.
You still got to put up people for
It's
coming.
close by.
All these guys coming.
I don't think in small towns like
Someplace.
Tennessee, you're going to find even anywhere to go rent equipment. No, I just.
We have to card it in from Jackson. probably.
And we don't have
And
any.
they won't give it to you. That's the problem. See, people won't just give you their recording equipment if they're a sound company. They want you to pay the person to come run the recording equipment, and that's where all your money comes in, because you're paying labor for this person to bring it and run it. Because they're not going to be like, have fun.
Mr. Chairman, I'd like to make a motion just to get something to talk about here. That the dates on this attachment, April through December, be approved.
Second.
Motion has a second that the dates of April through December be approved. Where we go is still up in the air, so any discussion on the motion that these dates be?
Well, if we approve the dates, then that's pretty much gonna kind of affect our location.
Not necessarily.
Well, but we change our dates according to whether we're in Nashville or out of Nashville.
Not necessarily.
No, for me it does. You're talking about when we travel, we do Thursday and Friday.
Why don't we go with the Wednesday, Thursday dates in Nashville, the May dates in Cookeville, and the October dates in Knoxville?
It leaves out West Tennessee. It's the only problem so far.
We need to go to Memphis.
Memphis in May?
We could go to Memphis.
Is there a barbecue down there sometime? Is there a barbecue festival?
We go to Memphis at night and
Somewhere in May.
and then
It's really late in the month, though.
and then go to
Move the meeting.
It's late. I looked it up, believe it or not.
It's the third weekend of May.
It's the third week.
Hey, why don't we go to Livingston then? Can you arrange for that?
Well, why don't we just say West Tennessee in May, and
Why don't we
then we
just-
can determine where.
Why don't we vote on my motion, Mr. Chairman, so we can get these dates pinned down, and then we'll figure out where we're going next.
Well, because when we go out of town, we do it on a Thursday and Friday.
Don't have to.
Well, we do.
We've done it. We don't have to.
We'll find you a place in West Tennessee and make something.
I mean, we can always go back to Jackson.
Is the 9th and 10th, is that a Wednesday and Thursday?
Thursday, Friday.
That's a Thursday, Friday.
Thursday, Friday, okay, we go, and then what about July? 10th and 11th is a what?
Wednesday, Thursday.
Once we do Thursday and Friday, go to Cookeville in July. And then in October, we're going to Knoxville.
Oh,
I
Ben,
sound like Rock. I said, that's my fault.
They're subject to
It's
change.
okay, we're going to Knoxville on my birthday, so.
Oh, okay. We'll have cake both places.
10th and 11th, October 10th and 11th is Friday, I mean Thursday, Friday. Well, duh, there it is. That's right. Okay, my bad. July, we can change that to the 11th and 12th. Go to Cookeville. This
and once we get,
Mr. Chairman,
okay,
I move to amend the motion to make May in West Tennessee, move July to the 11th and 12th in Cookeville, and October in Knoxville. No, July is Wednesday and Thursday is 10th and 11th, so 11th and 12th would be
How was the third one?
October 10th and 11th in Knoxville.
okay, motion has been amended. Mr. Greaves, any discussion on this motion?
He doesn't like
As
it.
amended.
Well, hang on, John's got a comment.
no, I have no thought except let's vote.
We're going to.
Give me a target to work for.
Second the amendment.
Got you one. Second is, it's seconded by Commissioner
Yeah.
Sharp.
I second.
I didn't hear you, okay.
All in favor say aye.
Aye.
Opposed, no.
All right.
Okay.
Progress.
Previous question on the motion.
Y'all got to figure out where West Tennessee is going to go. Okay. What's that?
Policy discussion.
Policy review.
Do you need notification?
We can change these dates.
I think it's just the dates they needed for the ALJ, not necessarily the places right this second. I think they just need, so they can reserve the ALJs
Okay.
themselves, I
And Robert said
think.
we cannot change these dates after, and if this month we go lock these dates in.
I mean, yeah, it's this month that we have to lock them in. Well, I mean, as long as we know we're in West Tennessee, then that, if they had to know, that'd be enough of a region, I would think, to get an ALJ.
Probably going to come from Memphis anyway. They're probably going to come from Memphis.
Okay.
So you want me to check Paris, right? In Millington?
I'll deal with it.
Okay.
You want her to check Paris stuff.
I'll take care of West Tennessee.
Okay.
Okay.
I can get on board with that.
Commissioner Norton's been signed to
What's,
that project.
now, next we have our policy review under the executive director's report.
Right, and Julie, oh, yeah, Julie wants to
Can I
have
meet,
her card again.
is David Allison here now? David Allison? Okay.
I think that's probably the guy that stepped out.
Please didn't get credit.
Julie's rewritten the policies that we discussed last month, just made the changes that we had discussed.
Yeah, I can go
So
through them one
she
by
can-
one if you want. We discussed these last month. I basically just made the changes that you all asked for. The ones that were amended, they're going to be renumbered because this policy as amended, of course, will take effect as of when we sign them. So the first one, which one's the first one on your iPads?
Commissioner,
The first one was previously numbered 89-CPS-005. Last month, you all voted to defer the matter until new language could be brought back addressing the passing of a licensee and also changing where it said affiliate broker to affiliated licensee. On the second page, the first page is the current policy as written now. The second page is the revised policy that I've put together based on what you all voted on. I just want to confirm that this language is in line with what you wanted, and then if so, get the chairman to sign off on this one.
Move it be approved.
Second.
We have a motion, Commissioner Alexander, and second by Commissioner Sharrow, that 2012-CPS-003 be approved in its revised form. Any discussion? Hearing none, all in favor say
change that date at the bottom.
Oh, I'm sorry. I can make that change. I thought it was going to be the second day. Please. I'll make that change.
with the date change at the bottom. All in favor say aye.
Aye.
No, motion carries.
The second one on your iPads is the one that was previously numbered 2001-CPS-001. Last month, you all voted to retain the first part of the policy, but to delete the second portion of the policy, 1 through 4, because it was contrary to the VLS statute, and so I have done that. You'll see it's policy now number 2012-CPS-004. It just removes that second part. And again, my date's incorrect, but I can change that.
Somebody like to make a motion
So
to
moved.
adopt this? Commissioner Alexander makes a motion.
Second.
Second by Commissioner Sharrow that number 2012-CPS-004, interest-bearing escrow accounts be adopted with the change of the date at the bottom. Any discussion? All in favor say aye.
Aye.
No, motion carried.
The third one is the one that was previously numbered 2008-CPS-001. Last month, you all voted to defer for me to speak with staff and change this policy to reflect the current practice, which I've done under number 3. The license expired for more than 1 year, and the new proposed policy based on that vote is now numbered 2012-CPS-005, which is also on your iPad.
What's your pleasure with this amended policy? Based on our discussion last month. somebody like to make a motion?
I move that we adopt the amended policy.
Second.
A motion by Commissioner McMullen and second by Commissioner Priest that we adopt this policy 2012-CPS-005. Any discussion? All in favor say aye. Opposed, no. Motion carries.
The next one is the policy formerly numbered 2009-CPS-003. Last month, there was a motion to change the language for the wording of the question that's included in this to reflect the actual language on question number 5 of the application, which I have done, and it is also on your iPads now as 2012-CPS-006.
Move that we adopt revised policy 2012 CPS 006.
Question. Again, this is referencing pleading and convictions in the same clause. Do we need to address that this time? We had that discussion this morning.
I think in this case, this is on an application for licensure, and it's just asking them to disclose either or if they have pled or been convicted. This is as a prerequisite. This is in the licensure application.
But you're asking for a certified copy of the conviction. And if they've already pled, there's not been a conviction, based on our discussion this morning, how are they going to provide you with that?
Do they provide copies in the cases where there is, in those cases most of the time, don't we have the plea in? Kelly, what do they send you in those cases?
If they've only pled. Well, if it's diversion. If it's diversion.
I don't review the, what has been what have they done in the past? What have they sent to you?
Well, if they pled guilty and it's diversion, then we have just that information from the court.
The certified copies of the
correct,
diversion.
just that shows exactly what happened, so that each time, if they pled guilty in the circumstances under which they pled guilty, and it's either been, as I say, diversion, or they've been put on probation, and that would be, the guilty plea will be basically wiped off, then that is all part of the court work.
Okay, so they send
But they are expected to disclose that and then provide the court documentation that shows whatever the disposition was.
Could I recommend some additional language to add there?
Yeah, nobody ever seconds your motion, Commissioner McMullen, so.
I'm going to change my motion. I move that we adopt revised policy 4 with the following language added, which is where it says certified copy of the convictions, comma, had documents evidencing the plea, and then it would leave or other documentation as required by the commission. Need a second.
I'll second.
Mr. McMullen has made a motion, and it's been seconded by Commissioner Norman that what he read into the record, he adopted as 2012-CPS-006. Any discussion?
It'd be right you sign it, don't you respond?
I know. All in favor say aye.
Aye.
Opposed, no. Motion carries.
The last revision we have here is the policy that was previously numbered 2010-CPS-001. Last month, you all voted to retain the policy but amend it to read informal appearances instead of informal conferences, as is multiply worded in the statute. So I've made that change and attached it as 2012-CPS-007 to reflect that change in wording.
Move to adopt the revised policy.
Motion by Commissioner McMullen to adopt this revised policy 5, which is 2012 CPS 007. It's been seconded by Commissioner Ishara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
That's all for policies.
That's all for the policy.
David Allison, are you here? Okay, got a card. I'll get it to you.
Where have you been? Do what?
hear, but you didn't hear your name called.
You didn't want to know that you'd been called outside. Does anybody have anything else, Ms. Maxwell?
I handed out some information on the budget and just a memo that I've written in the preliminary fiscal year end of 2011 to 2012. The memo, I just sort of go through where we stand and, you know, the going forward, what we might be looking at. And I've also included some historical data so you can sort of see where we were, where we're going, where we went, so that that, you know, so that everyone can see that. As I guess Assistant Commissioner Giannini told Chairman Stevenson this morning, I don't know, but we ended this year, at least according to the preliminary numbers, with a negative balance of about $53,600. And we have a reserve. This is in our just operating, day-to-day operating account. We had a reserve at the end of the fiscal year 2010 to 2011. We had a reserve of about 2.3. Now that reserve doesn't show up on our paperwork until we get the final closeout of the budget. But we, you know, we.
You're talking about this 2.3, that's $2,300,000.
But I'm talking about in our operating, you know, like in the operating account, not the education recovery account. I'm talking about just the operating account. That, I mean, if you look at our fiscal year from last year, in one of the handouts, you'll see one of the handouts that I gave you all. That you'll see that the end of that fiscal year, we had a reserve in our operating account of it's in the it's in the handout with the starts with fiscal year 97 to 98, and then if you go through it, you'll see the very last page, very second to last page. It's got the it's about 5 pages from the back. It's got the fiscal year 10 to 11, and it breaks down this page that has. I'm sorry it's not on the iPad. I was trying to make the long sheet bigger, and it didn't work. So it didn't get this one, the one that starts out with the numbers, that has the regulatory board's expenditures for the fiscal year, and it starts out 99-2000, and then it I sort of started from the back. So the fiscal year of 2010 is more towards the back, and you'll see that it's got 07, 08, then 08, 09, 9, 10, 10, 11. Can you find that page? It's and so that's sort of if you look at that, you'll see that we had you can see what the reserve was in 2007 to 2008. If you look down towards the bottom, and you'll see prior fiscal year reserve, you can see that at the end of fiscal year 10 to 11, the reserve, and as I say, this is in our operating account, just the day-to-day operating account, was $2,372,865. So about 2.4 was what our reserve was. So this year we had. Last year, you can see we had a balance just of the revenue that we had of $53,750. But then we had that reserve of $2,300,000. So our balance at the end of last year was $2,426,615. Now this year, on the preliminary budget numbers, it shows that we have a negative of $53,599, a negative balance.
Now, how did that happen?
Well, the reserve never shows up until, you know, it only shows up honestly on this sheet of paper, because it's not, what we have to do is we have to operate, you know, the revenue that comes in. Our revenue and expenditures as a reg board by statute are supposed to be approximately equal. So what the administration looks at is, okay, you've got this much revenue from your renewals and your licensing fees and civil penalties, and then you've got this many expenditures. And so that's what is initially is, looked at, are those numbers. And they are supposed to be, as I say, approximately the same by statute. And our revenue this year was down, obviously, because our license count is down in both renewals and initial applications. So that number is down. We have these cost backs that the administration charges for just running the regulatory boards. And in your packet is the formula that's used to figure out the cost backs. But our cost backs this year were $666,000. So that, prior to the cost backs, we weren't in the red, but after the cost backs, we were $53,000 in the red. And so, as I say, the cost back is an adjustment that's made at the administrative level to spread out the administrative cost amongst all the regulatory boards. So that's where, and our expenditures are down. In the last 5 years, we've lost 7 employees that haven't been replaced. Right now, we're down, as you know, an auditor since Bill Stewart retired. And we were down, when Donnie Bates retired, we went from February of 2010 to August of 2011 without, that additional auditor. Now that, we had some additional travel expenses that went along with that because Bill Stewart was going from Knoxville across the state to Memphis and made a number of trips in that direction for the better part of 18 months. So that, that was an additional expense. But on the other hand, it didn't outweigh what we saved on not having that auditor here. We're getting ready to put all our files in an off-site location to clear up 3 file rooms that we have paper files in right now. It's about 1,100 plus square feet at $20 a square foot, so that'll save us about $24,000 a year.
You get $20 a square foot for storage space?
For the files are stored on site here, and so we don't set our rent. It's just like
the state's just playing with our figures.
I mean, it's not just us. It's every.
That's why we're going corporate.
That's right. That's why we're going paperless.
One is fireproof.
Yeah, that's why we are. Yeah, that's a lot of the boards have a lot of files. So yeah, so we're going to save some money.
Let's make sure our landlords for letting their files get wet.
I don't. Well, I don't know. We destroyed those files. But anyway, so the good news is we're going to save money though because we're going to move them to an off-site location. So that's the good news.
The number of licenses that they reference here is 29,000. Does that allow them to apply more cost back or less if it's less than that?
Well,
our numbers now are 23.
right, but that's taken as off the governor's report that they run on actually, they take all of our disciplines, so all those numbers that I read you earlier that included what we call 2501 to 2510, which are the professional codes. They take the licensees in those codes, and we pay $5, per licensee to the state. So that's figured off that number that they run as of June 30. So that's where that number came from. Now, last year, in all of the disciplines that all the disciplines, I got them to remove 2 categories, the rental location agent and the rental location firm, because we don't have any activity in those, and those people just, they're just there with a license and. Well, I mean, it's figured on all of our licensees. I mean, so like, it's.
Our numbers are 4,000 firms.
Correct.
Including the firms and that $39,000 cost.
Yes, they're including all of our licensees except for those two categories that I had asked them to remove last year. So they're including, all of the licensees that we have are included in there, and it's, as I say, it's run off they run it off the system as of June 30, and that's the number that goes into the governor's report that is run, that has the licensing statistics in it. And so that's what, and it doesn't, it doesn't agree like with ours today for all the licensees. But that's what that number is based on. And then you can see if you look at the cost back formula, it also includes investigative costs, just like a base price for those based on the number of complaints that you have, looking backwards for a period of time and then looking to the present time. And that's figured up every year by FNA, and that's the price that we're billed. And you can look, I've got the cost back set forth for the last 3 years, and then the formula that is used for figuring those. So you sort of get an idea of...
I was going to say, Redison administration was more kind to us than we're currently being dealt with.
So, yes, anyway, so that was so the cost backs are a large part of what we pay out in our budget, as is, and you can see, if you can barely see this is a sheet I tried to blow up so that it would be a little more clear, but I couldn't get it to blow up. It kept eating the piece of paper we were trying to run it on.
I think Commissioner Grease has a question.
Yes.
How encumbered is that reserve balance? Can the governor come and reach in and get some of that money, or is it strictly for our use?
They can come in and reach in and get any money. They got our education recovery fund.
Yeah, we were laughing. About 5 years ago, the Redison administration came in and took, $4.5 million of reserves we had.
They borrowed it?
They borrowed it. Nothing. They just took it. They borrowed it all right. Forever they borrowed it. Put it in the general fund.
If you look on, I'm sorry as I say these are short, I tried to divide them into things that were logical, but obviously that didn't work out very well. The last 2 sheets of the handout with all the numbers on it, it has the Education Recovery Fund, and you can see that when it was swept, it had like $599,000 in just the interest fund. And the big fund at that time had about it was in 2008 that they swept it, and it had about 2.4 at the time, and now our interest fund has like about $20,000 in it, and the big fund has $3.8 million in it, the big Education Recovery Fund. But any of those could be monies could be taken from any or all of those funds at any time, I guess. And I mean,
they made a decision what they contemplated next when it was to inspectors, auditors, how would it title us? We share it with other regulatory boards or individuals?
but they talked about that when Deputy Commissioner Myshak was still the Assistant Commissioner. And after looking at that, it never was pursued. I mean, we met a few times with David Key, who's in charge of the investigators, and we had to, we made up a list of things that our auditors do, and we met with his investigators to sort of explain what our auditors do. But then they don't have, they only have like, I don't know, they did have 15 investigators. They may have now 16 to do the whole state and every reg board. So I think that was just one of those, it just didn't get, they didn't pursue it. Which is not to say that they won't pursue it, but at that point, I think it just turned out to not be a feasible alternative. on rare occasions, we'll use investigators if the legal department decides to send something out for investigation, but we always send our auditors. Exactly. We pay, but now, in our cost back, we have like a base fee for the investigators.
Anyway.
Correct. We're paying a fixed amount anyway, but then when you use them, you pay, you pay a fixed amount for the privilege of using them, I guess is maybe the right way to say it, and then you pay when you actually use them. But we try at all costs to use our auditors, unless it's a situation that it seems like we had the investigators, we had 10 hours of investigative billable hours for last year. And one of those was at a timeshare investigating some tapes that were sent to us. You know, it was sort of an undercover affair. Aside from that, we try to use our auditors for everything that we can use them for, because they really know the business and know how to do it best. You all can take this home and study it at your leisure. I just wanted to bring it to your attention, and as I say, I just sort of wrote a brief little memo and then tried to give you enough historical data so you could study it and take it to heart, or do whatever else you like to do with it. And I think that's...
Is that your report?
Yeah, I think that's... did you want to talk about the Post 120? Or do you want to...
What?
The Post 120? The broker Post 120? The principal, the broker...
You go ahead and explain.
Okay.
The travel amount budget, would that fall? I'm trying to see if it fell or it's the same.
The travel amount actually went up based on the auditors having to travel. The auditors are added in this part of the travel budget. So when you see this, it's not necessarily what we traveled, it includes them as well. No. Well, and I talked with Chairman Stevenson about whether or not the commission wanted to discuss asking for an Attorney General's opinion about the use of the Education and Recovery Fund. I talked to Assistant Commissioner Giannini about it again last week, and I don't know if he talked about it this morning, but he says a number of discussions about it, and the current feeling amongst the legal department is that it can't be used to pay for conferences, and so that that harkens back to 5 or 6 years ago when that was determined that it couldn't be used for that, because I believe prior to like 2005 or 6 it was used for conferences. And if you use it for conferences, like we talked about last time, I think you would have to make a report so that it would benefit all the licensees of the state, make a report, and it would go in the newsletter or be posted online.
The statute has not changed since then.
No, and as a matter of fact, there was a rule that further sort of clarifies the statute that says that it can be used for says it can be used for conferences and seminars, and I don't know. It's just not the way it's interpreted.
What would prevent us from asking for an AG's opinion?
I think you can ask for an AG's opinion. I discussed that with Assistant Commissioner Giannini about whether or not that would be the way to try to get some sort of a resolution of it. I don't know how long it would take to do that, but this Rule 1260-1-.11, seems to allow for attendance at seminars and conferences. It actually says that. So I don't really know anything other than what I've read in previous minutes that was handed down, back in, as I say, 2005 or so.
We're going to be required to follow the statute, and the interpretation is depending that happens. Then why not let the ultimate call make that determination rather than have someone in the administration make it?
Well, that was sort of...
Would you like to put that in form of a motion, Commissioner North?
So moved.
that we asked for the AG's opinion as to whether or not interest on our recovery fund can be used for conferences and for travel.
Educational
And
conference.
that's
And
the,
education conference, that's in a relo.
and that the departmental administrative staff rigorously pursue a response to that, and not just let it sit on the shelf.
Have a motion, do I hear a second?
I'll second that.
Have a motion and a second. Any discussion? Over in the vote. Hearing none, all in favor say aye. Aye. Opposed, no? No. No. Have one no, let the record show. We have 6 yeses and 1 no. Do you have anything else? That, just very quickly, there was an issue that I brought up when we first started this morning about a broker who did not complete his 120 additional hours as within the required 3-year period. What happened at the end of that 3rd year? Ms. Maxwell?
At the end of the 3rd year, prior to the end of the 3rd year, one needs to make an election as to whether one is going to downgrade the license back to an affiliate, and it has to be a written request, or there is, you can sign a consent order and have an additional 12 months in which to complete it, and there's a $50 civil penalty per month. It's statutory that within that 3-year period, the broker get those 120 additional hours. And so Mr. Pugh had come to the commission meeting several years ago in 2006, or early 2007, and said that the commission itself can't alter what's required in the statute, which is you've got 3 years, that you all can't extend that. But in order to, we have, basically you have a 4-year license when you sort of look at that. So that person has 3 years in which to complete their education, but there's another year left before their license comes up for renewal. After the 3 years, technically, the commission could file a complaint and revoke individuals' licenses just like we do for E&O. But in order to avoid doing that, the commission determined that they would charge a $50 per month penalty. But at the end of that 4th year, you have no license, period. So you have no choice, you have no license. It's just, it's over because you technically were on a year that you hadn't complied with the statute in the first place.
In that the period between the 3rd and the 4th year, they can request to downgrade.
It's supposed to be done prior to,
It has to be done before.
it's supposed to be done before that, and we could open complaints against everyone who has not completed their post-broker within the, that 3-year period. We haven't been opening complaints, but, we could do that according to Mr. Pugh if that's, if that's the route we end up having to go.
So basically, you have to request a downgrade before the end of 36 months. And then you can buy another 12 months for $600.
And sign a consent order, and pay. You have to, and you have to have complied with those things, and you have to get your education in that time frame.
And after that, nothing else matters.
Correct. Because that's what the statute requires, and any request has to be in writing. So we can't automatically downgrade somebody. Because when you turn in your, when you go for a broker's license, to get your broker's license, you've already turned in your affiliate license. So you don't technically have that license anymore because you turned it in, since you only have one license. And if you want to downgrade, then you can do that, but the rule requires that it be done in writing, regardless of whether, as I say, whether Bear decided today he wanted to downgrade. He could do that, but he would have to give us a request in writing. Otherwise, we would have people saying, well, I didn't want to downgrade. Why did you downgrade me? That's just not what I wanted to do. So those are the things that are required. And as I say, it is statutory. So there's not a, well, I kind of complied, or I sort of complied, or I technically complied. There's not any, it's either you complied or you didn't comply.
Anything else to come before this before this commission.
Just
Commissioner Greaves.
since you were talking about legislation, I know Mr. Sexton is still in the audience here, and you've conveyed our sentiment about that proposed legislation next year, right? You're working on that, correct?
Yeah, Chris Sexton with the Tennessee Association of Realtors. I've conveyed it to our leadership. Our Government Affairs Committee meeting will be meeting next month, and we'll be talking about it amongst that group first. But I did make our Executive Committee aware, and they see support.
We probably need more than seem supportive.
I mean, until we get an actual proposal. I mean, we haven't seen the legislation, so.
You guys are going to be kind of writing it, aren't you?
I was under the impression you guys were writing it.
My impression was that your Farrell and his group are going to take care of writing the legislation for us.
We were under the opposite impression, but I will talk with Russ and talk with your legal counsel as well, and we'll work something out. Okay.
And we can't draft.
That's the reason we asked you all to carry the bill and draft it, because if you don't, it'll be a bill of the administration.
I have not, Russ and I have not sat down and talked about writing the legislation as of yet.
Convey that to him.
I will.
Thank you.
If he's got any problem with it, let us know.
I will give you a call.
Okay.
Thanks, Chris.
Thank you. Anything else to come before this meeting? Commissioner report. Not on our agenda, but Commissioner Alexander?
I'm fixing to go home. Thank you for that.
Commissioner Greaves?
No report.
Commissioner Bashara?
Nothing to report.
Mr. Northern?
Report your item.
Mr. McMullen?
No report.
Commissioner Groveman?
Our local board went from 650 the last 3 years to 321. I think it's impacting smaller areas more so than it is metropolitan areas, the drop in number of agents. And also I had 3 complaints from other brokers this month about people managing property without license, and I think it's running rampant. One of them was a supplier of, did maintenance work, and he was collecting money for people, and I think that we need to keep our eyes open for stuff like that, and that's all I have.
Okay. Staff have any comments? Kelly?
I was just thinking about the Christmas luncheon. We can talk about that next time.
At this time, no other business comes before this commission meeting. I want to remind all of you to sign out when you leave. And Steve?
Sir?
You're in charge of these licensees. Whatever y'all did, there's only 4 of you here for continuing education. The rest of you are here probably because you didn't really want to be here, but you only get 8 hours of continuing education. Take what you've learned back to your offices and share it with your fellow licensees. Yes, Mr. Greaves. Yeah, you do not have to come back tomorrow. See who will? Yeah. Okay.
Oh, you're at the bottom. I didn't.